many times. You're in good hands with them, all right?
Okay, sounds good. Okay.
Judge Draper, good morning to you.
Good morning, Your Honor. How are you today?
I'm well. Who is your client?
Shamil Gappy, Gappy. He should be getting on in one moment.
What's okay? Shamil Gappy. All right. We're gonna get going. He's not set to be here until 9. We're gonna give the officer that half-hour grace period. But if the officer does show up before 9:30, we'll get you in a breakout room. You can go to room 4, and if you can work it out ahead of time, that's fine with me as well. All right.
Thank you so much.
Get on the city attorney.
I'll go to room 4. Thank you, Judge.
You're welcome. Okay, good morning, everybody. Let's get going. I know it's Friday. Everybody wants to get out of here because it's a nice day. Gonna be a nice week. Let me that tape, Tavi iPhone.
Yes.
Morning to you, ma'am. What is your name?
Artavia Little.
Artavia Little. Good. You got a. Let's see, let's go. Little, you're free to leave. I'm dismissing your case, okay?
Thank you, Your Honor.
Best of luck to you, ma'am.
Thank you.
Come on.
State of Michigan 36th District Court is now in session with the Honorable Judge Sean B. Perkins presiding. While court is in session, there will be no smoking, eating, drinking, sleeping, and or laying down. I will ask that if you have on any hats or hoodies that you please remove them unless due to religious purposes. And I will also ask that you keep your phones, your devices on mute until your name is called. Thank you, everyone. Good morning to Judge. Good morning to everyone.
All right, good morning, everyone. Again, like I said, I'm gonna try to get you out of here as fast and efficiently as possible, and I'm gonna try to get you out in the order that you came in. Madam Interpreter, are we ready to swing?
Yes, sir.
Madam Interpreter, can you state your name for the record, please?
Diana Huang.
And can you raise your right hand, please? Do you solemnly swear or affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge confidential communications, so help you God?
Yes, I do, Your Honor.
And do you swear or affirm that to the best of your ability, you'll interpret from English to Chinese and Chinese to English?
Yes, I do, Your Honor.
This is the city of Detroit versus Kang Jen Lee, case number V503385525. Appearance for the record, please.
Diana Huang，把你的名字报上来。
我的名字叫李康珍。
My name is Lee Kang Jen.
All right, good morning to you, ma'am. Today is the date and time set for a pre-trial. I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
今天是预审，然后刚刚你跟那个程氏律师聊过，法官问程氏律师你的意见是什么样？
Erica Harris on behalf of the defendant.
他说他是你的代表律师是 Harris 律师。
And she was able to present a valid license.
所以你已经就是拿到了给他看了你的有效的执照。
Is that Officer Clark from BC?
Yes, sir, Your Honor. I'm here.
Are you here on behalf of Ms. Lee?
Yes, I am, sir.
这个是你的代表律师。
Do you want to review that license, or are you in agreement that the license is valid?
I'm in agreement. I see that the license is valid.
他说他看过你的执照是有效的。
All right, good morning to you. Case dismissed.
你的
By
案
valid documentation.
Good morning. Thank you, Your Honor.
Okay, Ms. Lee, you're free to leave. Have a very good rest of the day. And thank you, Ms. Kang. We really appreciate it.
You're welcome, Your Honor. 好了，你可以走了，你的案子撤销了。
Yeah.
Thank you.
This should be a trial date for this one.
Is it a separate? That's a continued from the election.
Okay, so you're just.
All right, is Otis Gorman here? Kevon Latimer, he's the young man that had the brandy flowers. City of Detroit versus Anthony Javon Gant, case number SP 167-84731, SP 168-3585, counts 1 and counts 2. Go ahead and strike that. SP 168-3585, counts 1, 2, and 3, and 17-26-34851. Appearance for the record, please.
Elwood S. Berry
Harris?
Jr. On behalf of the defendant, state your full name, Mr. Gant.
My name is Anthony Javon Gant.
Okay, good morning to you, Mr. Gant. I prematurely called your case. I was just, you're at the top of the list, but it doesn't start till 9 o'clock. As soon as the officer gets here, we will, if the officer doesn't get here before 9:30, then if the officer doesn't get here, if the officer gets here before 9:30, we'll get you heard and we'll get you in a breakout room. If the officer doesn't make it until after 9:30, we'll get you out of here, all right? So I'm gonna pass the matter. It's a trial. I'm gonna pass the matter and we'll get you out of here as soon as we can, all right?
All right, no problem.
Mr. George is who was on a Samsung device? Who was on a Samsung device that I had to rename? Okay, let's go down to Oval Street. Let's get down to Leadbetter.
Good morning, Judge.
Good morning to you. He's in a payment plan for some stuff as well. That's old stuff though. This is the City of Detroit versus Charlton Leadbetter, case number SP 143-4257, counts 1 and counts 2. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant, state your full name, Mr. Leadbetter.
Charlton Solomon Leadbetter.
Your Honor, for purposes of arraignment, my client would waive the reading of the information and stand mute.
We'll enter a not guilty plea on your client's behalf. We'll give your client a $0 bond. He's in a payment plan for the no plates on this, and the allegation was made at the same time. He's almost paid that ticket off. He only owes $41. Get him an updated offer. Keep him, Mr. Leadbetter. If you don't like the offer, you have an absolute right to a trial, okay? I'm gonna put you in a breakout room with Mr. Barry. Have a conversation with him. Let us know what you want to do when you come out, okay?
Thank you, sir.
You're welcome. All right, he's in there, Mr. Barry. Let's pass the matter. City of Detroit versus Desmond DeMar Lewis, case number SP 1699281. Appearance for the record, please.
Good morning, Judge.
Morning to you.
Erica Harris on behalf of Mr. Lewis, please state your name.
Desmond DeMar Lewis.
All right, today is the date and time set for a pre-trial. Give Mr. Lewis an updated offer. Keep in mind, Mr. Lewis, if you don't like the offer, you have an absolute right to a trial. Join the breakout room. Let us know what you want to do when you come out. Let's pass the matter.
Thank you, Your Honor.
Attorney Weiner, good morning to you. Counselor, you have to unmute yourself. Eddie's iPhone, good morning to you. Can you unmute yourself, start your camera, and state your name, please? Eddie's iPhone.
Hello.
Good morning to you, sir. What's your full name, please?
Lester Lay.
Lester Lay?
Yes.
All right, good morning to you, Mr. Lay.
Good morning.
Your matter is set for trial. If the officer, I'm gonna give the officer a half-hour grace period from 9 o'clock to 9:30. If the officer does not show up, we'll get you out of here. If the officer does show up, we'll get you in the breakout room with an attorney, okay?
Excuse me, Judge.
Yes.
I thought I was here for traffic.
You are. It says trial though. It says trial, so you are. It's on the iPhone. Good morning to you. Can you unmute yourself? State your name. iPhone, I'm asking you to unmute yourself. I'm sending you the prompt, please.
How do we know which iPhone you're talking about? Because
I'm sending them the prompt. Good morning, Ms. Gaskin. I have you already checked in.
Okay, thank you.
They should see the prompt.
Is it me, officer, or judge?
Do you have a shirt on, sir?
I can put one on.
Listen, don't do that. I don't understand why you can't. You come in here without a shirt.
Now I had my robe on. I was in the bathroom. I wasn't
I
anticipating.
don't need to know all that either. I'm gonna put you in the waiting room. Go get yourself together. All right, iPhone, you unmuted yourself. Good morning to you. State your name, sir, please.
Name right there.
Marvin Owens.
Marvin Owens, good morning to you.
Good morning, sir. Yes, sir.
The admin device. I just let you in the room. Can you unmute yourself, state your name, please, and start your camera? Admin device.
Me.
What's your name, please?
Shamil Gappy. Oh, what's
Geppo? All right, you're gonna have to turn your camera on. Spell your name for me, please. Turn your camera on.
Never be talking to you when you say your name.
All right, you got your camera on. What is your full name, sir? You have to unmute yourself now. What is your name, sir?
Ecwan Eckles,
Yeah, good morning to you. What is your name? Geppo? On the admin device.
Oh,
You, sir, what's your name?
it might be Shamil Gappy.
Gappy. Okay, your attorney.
Thank you,
Your
sir.
attorney, Mr. Gappy, I'm gonna put you in a breakout room. Join the room. I'm gonna let them know you're here, okay?
All right, thank you.
Your Honor,
All right. Go ahead, Mr. Barry.
my client, Mr. Leadbetter, needs the services of Mr. Patel.
Okay. Join breakout room 20, Mr. Gappy. I'm gonna tell your attorney you're here.
All right, thank you, sir.
You're welcome.
Hey, Your Honor, this is Sergeant Easton.
Good morning to you.
Yes, sir. I'm here on Rosalind Green. I just need to check in because I do have court at Judge Milhouse's room. I have 2 other courtrooms too I didn't check into.
You're checked in, all right?
I appreciate it.
Let me get some of these people named that we can get back going. I didn't get your client's name, Attorney Wyman.
Keith,
Good morning.
Keith Griffin. I think we got like six cases up this morning. I think it was set for trial. I think you said it last time, said it for trial. Keith Griffin. Has he logged in? I think he has.
Keith Griffin, yeah, I think he's Keith. This may be him here. Keith Griffin. Is Keith Griffin here?
I know I spoke with him this morning and he said he was logged in. I think I see him under K where it says Keith, maybe just that name.
Keith Griffin. He's not responding.
Let me call him and make sure he logs in, Judge.
Good morning.
Hold on a second. Good morning, everyone. Hold on a second, please. On the iPhone, I'm gonna ask you to unmute yourself and turn your camera on and state your name, please. iPhone, I'm gonna ask you to unmute yourself, start your camera and state your name, please. All right, that's cut off for officer. Say that again, sir.
Terrence Grave.
Graves, good morning to you.
Good morning.
Yeah, yes, Judge, yes, Keith Griffin said he logged in. He's logged in now.
I don't think he's unmuting himself, though. Keith Griffin, are you there?
Yes, sir. Good morning.
Okay, that's something. Good morning to you. I'm gonna put you in breakout room 5. Wait on your attorney. He's
Okay,
gonna come
thank you, sir.
speak. Okay. Attorney Weiner, you go to 4 and wait on the city attorney, please.
Okay. Are you gonna? You're gonna prompt me to do that, Judge, somehow?
You can do it yourself. You have abilities, but I can in a second.
Okay, I don't know how to get into the waiting room. I'm still trying to figure out my pager, Judge. Thank you.
All right. All right, let's need to name a few more people. That's good. Thank you for doing that. On the iPhone, I just let you in the room. Can you start your camera, unmute yourself and state your name, please?
Talking to me again?
No.
All right.
All right, gentlemen, on the iPhone, you unmute yourself. Good morning to you, sir. What's your name, please?
Malik Lakis. Good morning, sir.
Good morning. Amani, what?
Malik, M-A-L-E-K. Last name L-A-K-K-I-S. Malik Lakis.
Thank you.
Are you, I don't know if you're in the right place. Do you have a case number? Do you have a case number?
845.
Yes. Okay, good. You're in the right place. Good morning to you.
Thank you.
Let's get back to one. Let me get this one other person. Good morning to you. On the Chairman Yarto.
Yeah, you know what? It's my friend, so I'm gonna change my name. I put his name there.
What's his name?
Ogonyinka.
Oganika. Does he need an interpreter?
No, I just have to change my name and then give him the seat, that's all. Just a minute, I'm trying to find. Okay, there you go.
Do you see, I don't see the docket. Do you see him on the docket, Ms. Harris?
There you are.
Yes, Your Honor, 8:30,
30.
under Leadbetter.
Okay, thank you. All right, let's get that going. All right, so I'm gonna get the House councils going, and then I'm gonna take care of some of the retained council.
Good morning.
Hi, in court.
All right, let's go back on the, okay, let me get Mr. Patel. So, all right, let's go back. You're waiting on someone, right, Mr. Berry? Let's call the city. Well, Mr. Lomax, I'm getting, Mr. Leadbetter, I'm getting the services of Mr. Patel, so we'll pass Mr. Leadbetter's matter. Let's call the City of Detroit versus Latina Patrice Lomax. Case numbers SP 163-24761, SP 171-58131, SP 171-58114, counts 1, 2, and 3. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Ms. Lomax.
Latina Patrice Lomax.
Your Honor, for purposes of arraignment, my client would stand mute.
In a not guilty plea on your client's behalf, will give your client a $0 bond. Ms. Lomax, I have 1, 2, 3, 4 cases. 1, 2, 3, 4. I have 4 cases on the docket, Mr. Berry. I called 5 into the record. The other case is a civil infraction in a school zone. I don't know if that's speeding or not in a school zone. I don't have any issue with setting that matter aside if the city attorney does not have any objection. Ms. Lomax, Mr. Berry is going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. I'm going to put you in a breakout room. Let us know what you want to do when you come out, okay?
Yes.
Join the room, please.
Yes, Your Honor.
Let's go back on the record with Mr. Lewis. Mr. Lewis, Desmond Lewis, I've given you an opportunity to speak to counsel. Counsel, what's your client? Your client wants a dismissal for valid documentation. Is that correct?
That is correct.
Mr. Lewis, I'm going to dismiss your case for providing valid documentation. If there's nothing further, you have a very good day, sir, and I wish you the best of luck. Have a good day. Case dismissed.
Thank you, Your Honor. Have a great day.
Thank you as well. Leverett, are you there?
Yes, good morning, Your Honor. I'm here.
Good morning. 1 second. This is the City of Detroit versus Ariana Latrice, case numbers SP 1677956, counts 1, 2, and 3. Appearance for the record, please.
Sherika Harris on behalf of Ms. Leverett. Please state your name for the record.
Asian Leverett.
Good morning to you, ma'am. Day is date and time set for a pretrial. Ms. Harris is going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. I'm going to put you in a breakout room. Let us know what you want to do when you come out. All right, Ms. Leverett?
Thank you. Okay.
Your Honor, was there a request for an appointed attorney?
No, it was not.
Okay.
Join the room, please. Let's pass the matter. Attorney Barrett. Good morning to you. Okay. Attorney Marable. Sheely. Attorney Payne.
Good morning, Your Honor. I'm
Good
here
morning.
at the trial on Tonette Garrett, who is also here.
Tonette Garrett is here. I'm gonna put Ms. Garrett in breakout room 6.
Okay.
You have privileges. And Ms. Garrett, we're gonna get you out of here as soon as we can, all right? We're waiting on the city attorney.
Okay. Thank you.
Good morning, Ms. Garrett.
Good morning.
Join the room, please. Wait on your lawyer, please. Mr. Gardner, are you there?
Yes, I'm here, Your Honor.
Mr. Boffman is here. I'm gonna put you in a breakout room with him. Mr. Boffman, are you there?
Good morning, Your Honor. Happy Friday, everybody.
Happy Friday. I have Mr. Gardner. Here's the deal with Mr. Gardner. The trial was set for June the 18th, 2 days ago. There was some miscommunication. I believe that was on our end. But Mr. Gardner needs to speak with you, and we'll just reset the trial date for that. So I wanted you to speak with him now, and then when you come back, we'll reset the trial date. We'll put you in breakout room 7. Join breakout room 7.
Thank you, Your Honor.
You're welcome. Uncle PJ. Uncle PJ.
Yes, hello.
Good morning to you, sir. What is your name, please? Because I'm not going to call you.
Yeah, I know. Good morning. My name is James Longmire. That's just my email screen name.
All right. Longmire.
Yes.
All right. Good morning to you, Mr. Longmire.
Good morning.
All right, who are we waiting on? Let's go back on the record with Ms. Leverett. Ms. Leverett, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, my client is respectfully requesting appointment of counsel and a trial date. I am placing her contact information in the chat.
July 17th.
All right, I'm going to give you a pretrial date of July 10th, Ms. Leverett, at 8:30. I'm going to ask you to answer the calls you don't recognize. One of those calls should be that appointed attorney. If you don't hear from that appointed attorney by the July 10th date, we'll get one appointed to you on the spot.
Okay, thank you.
Do you have any further questions now?
No, Your Honor, thank you.
All right, so if you don't have any further questions, I wish you the best of luck. Have a
Appreciate
very
it.
good day.
You too.
See you July the 10th. All right.
Okay,
At 8.
thanks.
Mario Gregory. Mario Gregory here. All right. Mario Gregory's not responding. Mario R. Gregory.
Yes, I'm here.
Are you there?
Yes.
He's breaking up. Oh, this is the second. All right, the date and time set for trial for Mr. Gregory. I'm going to give the officers a half-hour grace period.
Kind of low, I guess.
Yeah, I'm here. If they don't get here from by 9:30, we'll get you out of here. If they do, then we'll get you in a breakout room with the lawyer. All right. Give me a few more minutes.
All of them came up and said.
Good morning, Judge.
Good morning.
I think I'm one of the officers here for Gregory. I don't know if there's more than one.
Yeah, let's see. If all the officers are here now, we'll get going.
Yep, I'm the officer here for Gregory as well.
Good morning to you.
Good morning.
So I have, that's Miss Barrett's case. Officer Burks, Dodd, and just Burks and Dodd, right? Those are the only two? Okay, what we'll do is Mr. Gregory, Miss Barrett is here. I'm gonna put you in a breakout room 8. I'm gonna put you in breakout room 8, Mr. Gregory. Join the room and wait on Miss Barrett, all right? Gaskin, D. Gaskin.
Good morning.
Good morning to you. Where's Miss Gaskin?
Right here. You don't see him.
There we go. All right. Good morning to you, ma'am.
Good morning.
This is the city of Detroit versus Demetria Gaskin. Case number SP 1196924, counts 2 and counts 3. SP 1282708, counts 1 and counts 2. SP 1528791, SP 1555741, SP 9805921. Appearance for the record, please.
Erica Harris, on behalf of Ms. Gaskin, please state your name for the record.
Demetria Gaskin.
Is the time set for arraignment on the bench warrant, counsel?
For purposes of arraignment, my client stands mute.
Enter a not guilty plea on your client's behalf, give your client a $0 bond. Your client does owe a no insurance proof 288. That's the only thing I can see here is affecting her license. I'm a Ms. Gaskin, I'm gonna put you in a breakout room with Ms. Harris. She's gonna get you an updated offer. Keep in mind, if you don't like the offer, you have an actual right to a trial, okay?
Okay, thank you.
Join the room, pass the matter.
Good morning, Your Honor. This is Officer Nelson. I'm checking in on Longmire.
Longmire is here. Good morning, Officer Nelson.
Okay, and I do have to check back into 340.
Okay, you can go check into 340 and come back. We'll be here.
All right, thank you, sir.
Your Honor, can you tell me if I have a case in your courtroom? If you can discuss it.
All right, on the telephone at 313-471-8420. Good morning to you. What is your name, please? I just let you in the room on that telephone.
Yeah, this is Hello.
So what's your name, sir? Good morning.
My name Calvin Green, sir.
Good morning, Mr. Green.
Good morning.
All right, Calvin Green, Calvin, Kelvin, right?
No, Kelvin. Yes, sir.
Then it's Griffin.
Yeah.
I'm gonna sit tight, Mr. Green. It's gonna be a minute.
Okay, sir.
Ms. Griffin, you're not supposed to be here until the 23rd.
You said the 23rd?
Oh, not you, Mr. Green. You're supposed to be here. Ms. Griffin is not supposed to be here until the 23rd. Candace Griffin.
Yes, sir. Okay.
Best of luck to you, man. Have a very good day. We'll see you back on the 23rd.
Yes, sir. Thank you. Have a good day.
You too. All right, I'm on the record. Let's go back on the record with Ms. Gaskin. Ms. Gaskin, I've given you an opportunity to speak to counsel. Ms. Gaskin, you want a pretrial date?
Yes.
All right, I'm gonna give you a pretrial date of July the 10th, 2025 at 8:30. If there's nothing further, ma'am, I wish you the best of luck. Have a very good rest of your day.
Thank you, too.
Thank you. Do we have Joel Galvin Pina here? Espino, Gomez, Otis Gorman, DeJuan Graham, Kevin Ramsey, I got rid of him. DeJuan Graham, is DeJuan Graham here? All right, let's go with Glenn. Mr. Glenn, are you there? Raheem, Glenn. The City of Detroit versus Raheem Abdul Abdullah Glenn, case number SB 1231403, counts 1 and counts 2. Appearance for the record, please.
Sheriff Harris, on behalf of Mr. Glenn, please state your name for the record.
Raheem Abdul Glenn.
For purposes of arraignment, my client stands mute.
We'll enter a not guilty plea on your client's behalf. We're gonna give your client a $0 bond. Mr. Glenn, I'm gonna put you in a breakout room with Ms. Harris. She's gonna get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. Join the breakout room. Let us know what you want to do when you come out, okay? Let's pass the matter. Let's go back on the record with Ms. Lomax. Ms. Lomax, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, my client would avail herself of the people's offer to enter a plea to limited access 1 to 5 miles over for the school zone speeding ticket, and the remaining matters to be dismissed.
Is that what you want to do, Ms. Lomax?
Yes, Your Honor.
All right, Ms. Lomax.
Yes.
I'm inclined to not accept this offer. You're going 46 in a 25-mile-an-hour zone now, in a school zone.
I had my flashers on, my car was overheating. And
yeah, it's no excuse. That means you're in a rush to get to where you need to go. I understand your car it may be breaking down, but that's even more dangerous because it's kids out there. And you being in that rush. I'm gonna accept the deal this time, but you have to, you gotta be mindful. I understand you have a problem, but you gotta be mindful. Don't make that problem even greater problems and hitting somebody out there.
yes, Your Honor, I apologize. It won't happen again.
Stipulate to the face of the ticket as an accurate factual basis for that responsible plea on your client's behalf.
Yes, Your Honor, so stipulated.
Stipulate the probable cause for the dismissal of the other matters.
Yes, so stipulated, Your Honor.
I'll find your client responsible for the admitted count of limited access 1 to 5, $125. When can you pay it now?
If you give me maybe 30 days. Please, Your Honor.
All right, come back. No, you don't have to come back. Pay it by July the 25th, ma'am. If it's nothing further, I wish you the best of luck. Pay it at any DivDat kiosk in the city of Detroit. I'm told you can upload the DivDat app to your phone or come on down to the courthouse and pay it in person. Those are the two best ways I can tell you to pay it. If it's nothing further, Ms. Lomax, I wish you the best of luck and have a very good day, okay?
Yes, sir, and that's 125, correct?
Correct.
Okay, thank you so much, Your Honor. Enjoy your day.
Yeah, you as well. Thank you so much.
Okay, God bless.
You as well. Jamal Leighton.
Yes, I'm here, Your Honor.
Morning to you. Let's see if you're supposed to be here today. You said you were saying something, Mr. Berry?
I wanted to indicate that Ms. Snyder is away today, and I'm not sure if the prosecutor's office knows that.
We'll call down there. We have to get another. Mr. Berry, Mr. Leighton is not supposed to be here today, but we'll hear we'll call it. That's the cutoff for officers. Let me see if there's any officers in here. Give me a second.
You're right.
Can we call the city attorney's office and get a lawyer in here, please?
You may leave, Ms. Lomax.
Be here today.
I'm all set. Thank you.
Oh, you're all set, Ms. Lomax. Be safe.
Okay, God bless.
You as well. Give me that.
Yes.
Hey, good morning, Your Honor.
Good morning to you. Good morning, officers. All right, let's call it the city of Detroit, Mr. Berry. This is not on the docket. Versus Jamal Leighton, case number SP 1708230, counts 1 and counts 2, and U 714722625. Record, please.
No.
Is Ms. Lauder there? For the purposes of Mr. Leighton, state your name for the record, please.
Jamal Leighton.
All right. For the purposes of arraignment on the show cause.
Your Honor, we would waive the reading of the information and stand mute.
Winner not guilty plea on Mr. Leighton's behalf, give him a $0 bond. Get Mr. Leighton, we're just gonna come back on the 7th. We're gonna reset it to the 7th of June, strike that. The 10th of July, Mr. Leighton, we'll have your file here at that time, okay?
Okay.
All right, best of luck to you, sir. 10th of July, disregard any other dates, come back on the 10th of July.
Okay, what time? 8:30, the same time?
At 8:30.
All right, thank you, Your Honor.
All right, thank you. So Mr. Gregory, Ms. Barrett is here. I'll put him in the breakout room. Let's go down to Keith Lewis.
Your Honor, I'm sorry. Do you mind if I leave and come back? I sign in with another courtroom.
Absolutely. Good morning to you.
Good morning. Thank you.
Keith Lewis here.
Excuse me, Judge, can you?
Yes.
Barrett, you have your client is in breakout room. Your client, Ms. Barrett, is in breakout room 8.
I know, Judge. I also have Anthony Gant.
Anthony Gant, I'm gonna put him in breakout room 9. Mr. Gant, you're in breakout room 9. Ms. Barrett's gonna come see you, okay? I'm waiting on the city attorney, everyone, so give me a minute to get the city attorney here. Mr. Friedman, good morning to you.
Good morning, Judge. Your Honor, I'm here for Keith Lewis.
Who's Keith? All right, Keith Lewis. All right, I'm going to. Keith Lewis is here. We just called the case. Let's call it City of Detroit versus Keith Lewis. Case numbers SP 168-03932, SP 168-03933. Appearance for the record, please.
Your Honor, Bradley Friedman on behalf of Keith Lewis.
All right, Mr. Lewis, state your name for the record. Good morning. Can you put your appearance, your P number on the record, Counselor?
Yes, Your Honor. My P number is 70877.
All right, Mr. Lewis, good morning to you. State your name for the record, please.
Good morning, Keith Lewis.
All right, today is the date and time set for a pre-trial. Mr. Lewis does owe an expired plate, $222. Fairly recent, I don't know, last year. Let's run his license and see what his license looks like.
Your Honor.
Go ahead.
Your Honor, he has a driver's license appeal division hearing coming up. He's retained us relative to that. So his license, he currently does not have a driver's license.
All right, don't run his license. So I'm going to put you in the breakout room. You can get an offer from the city, or we can just set a trial date.
No, Your Honor, I'm looking for an offer from the city.
All right, I'm gonna put you in a breakout room. Wait on the city. Mr. Lewis, I'm gonna put you in breakout room 10. Wait on your attorney. If he takes a deal, make sure he's read his advice or rights. Join the room, Mr. Lewis has passed the matter. All right, Mr. Berry, you're waiting on someone, right?
Yes, Your Honor.
Let's see, this is Gains. Is that Tanya Gains?
Good morning, Your Honor.
Morning to you. This is the City of Detroit versus Tanya Gains, case number SB 17047541. Appearance for the record, please, Mr. Berry.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Ms. Gaines.
Sonia Celinda Gaines.
Your Honor, for purposes of arraignment, my client will stand mute.
We'll enter a not guilty plea on your client's behalf. We'll give your client a $0 bond. Ms. Gaines, Mr. Berry is going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. I'm going to put you in a breakout room now. This is one that when I look at the allegation on the ticket, there'll definitely be a gun safety course.
Yes, Your Honor.
And it's going to be a $500 fine if these allegations are true. If she pleads guilty to this, so gun safety course and a $500 fine. I don't know if the city's going to give her a delay or not. I have a copy of the ticket here, Mr. Berry, if you need to see it. But there was a victim here that said that she pulled out a firearm while they were arguing, and the victim described the gun. That's what the notes say. So those are the allegations. Ms. Gaines, I'm gonna put you in a breakout room with Mr. Berry. He's gonna talk to you and let us know what you want to do when you come out, all right? Join the room, please. Let's pass the matter.
Thank you.
Let's go back on the record with Mr. Glenn. Mr. Glenn, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, my client is requesting a trial date.
Is that what you want to do, Mr. Glenn?
Yes, Your Honor.
It's going to be July the 17th at 9 a.m., sir. July the 17th. If it's nothing further, I wish you the best of luck. Have a very good rest of your day.
Thank you, Your Honor. You did the same.
Thank you. All right.
Officer Williams, Your Honor.
Good morning, Officer Williams. I have all the officers checked in. If you need to go report somewhere, then go report and come on back, please.
Okay. Okay. Thank you.
Detroit versus Gerard Greer, case number SP 100899111, SP 1089981, SP 1284050, counts 1, 2, and 3. SP 1321447, counts 1, 2, and 3. SP 1394709, counts 1 and counts 2. SP 1522024, counts 1, 2, and 3. SP 1707960, counts 1, 2, and 3. Appear to the record, please.
Gerard Greer.
Cherica Harris on behalf of Mr. Greer.
All right, Mr. Greer, I'm only going to say it one more time. Do not come in my courtroom undressed or unprepared, okay?
Yes, sir.
All right. Good morning to you, Ms. Harris. I do not see anything here that has affected Mr. Glenn to get the driver's license. So get him an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. I don't know if he has a driver's license or not. So, Mr. Greer, join the room, speak with Ms. Harris. She's going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial.
Yes, sir.
Pass the matter. Ms. Marable, are you here?
Yes, Your Honor, but I have had one morning. I went to get my coffee this morning and ended up with a flat tire. So I'm at discount. I'm just getting out of discount tire, but I did want to get on Zoom. So can I keep the video? Do I have to start my video because I'm just leaving discount tire?
I know what you look like, Ms. Marable.
Okay, thank you.
Sorry for your unfortunate incident of the flat tire. What about Garrett?
Yeah.
She's in the breakout room. So have you spoken with her? You're waiting on
I talked to Mr. Garrett. I talked to Mr. Garrett this morning.
Mr. Garrett. Mr. Is that Johnny Garrett?
Yeah, Mr. Byron Garrett. So last week we were there, Your Honor, and you wanted to see a alcohol testing.
Oh, and he didn't do it.
Yes, he did. He did it that day.
Let's go get probation down here. I just signed something.
He did it that day.
That's why we hear both sides.
Okay.
Let's see here.
Let's go back.
Right. Yes. Let's get probation down here if you could, Ms. Lurch. All right, I'm waiting on a lawyer. Any lawyers ready? Any other lawyers ready?
Ready on Greer.
Let's go back on record with Mr. Greer. Mr. Greer, I've given you an opportunity to speak to counsel. Counsel, what does your client want to do?
Respectfully requesting a trial date, Your Honor.
All right, is that what you want to do, Mr. Greer?
Yes, sir.
All right, July 17th, 2025 at 9 a.m. If there's nothing further, I wish you the best of luck. Have a very good rest of your day, all right?
Right on, sir. Blessings to you.
Hey, you as well. Ms. Lee, Ariana Lee, are you there?
Yes.
Good morning to you, ma'am.
Good morning.
City of Detroit versus Ariana Latrice Lee. Case numbers SP 1692692, counts 1 and counts 2. Appearance for the record, please.
Erica Harris on behalf of Ms. Lee, please state your name.
Ariana Latrice Lee.
All right. Day is date and time set for a pretrial. Ms. Harris, give Ms. Lee an updated offer. Keep in line, Ms. Lee, if you don't like the offer, you have an absolute right to a trial. Put you in a breakout room, Ms. Harris. Let us know what you want to do when you come out, okay?
Okay, thank you.
Join the room, please. That's the matter.
Okay.
I'm still waiting on a city attorney, Mr. Boffman. Let me let the Zoom user in.
Okay.
Zoom user, good morning to you.
Good morning. How are you?
I'm well. Who is this?
This is Jeremy Odom.
All right, Mr. Odom, you have to turn your camera on, okay, please.
Okay, hold on. Let me see.
You did.
There we go. There we go. How are you?
I'm well. How about yourself?
Not bad.
Let me see here. Jeremy Odom. ODUM?
Yeah, they sent me to you from Kenneth Burley.
Is it ODUM?
It's ODOM?
ODOM.
Yes, sir.
Let me see. ODM. Spell the first name.
Jeremy, Jeremy.
You have a middle initial?
It's not on the ticket, but yes, M. M is my middle initial. Mark.
That's the wrong.
Yeah.
You're supposed to be informal hearing at 2:20 downstairs, 9:30. Informal hearing at 2:20.
Hey, what up, Frank? You all right, bro?
2:20. I can't be informal. I'm not in town, so it said a Zoom call at Kenneth Burley.
Yeah, so you can go to Zoom down there. That's, I'm sure that, can we get them the ID for 2:20? 2:20 informal hearing.
360-360-0220.
360-360-0220. And let them know that you have 3 other cases that I don't think you set dates for. That's a expired place, no valid registration, and no insurance proof. You need to set dates for those. Those are, if you don't set a date, it's due by the 26th. So to go down to there, you got these 2 cases right now. And if it's nothing further, sir, best of luck to you. Have a very good rest of your day.
Okay, cool. So call that. Okay, cool. I got you. Thank you so much. All right.
We got a city attorney. We need you online.
Yes. I can zoom in. That preferable.
Absolutely.
Yes. Just need a docket sheet. Yeah, thank you. How you doing, Mr. Thomas?
Okay, who are we waiting on? Are you waiting on me?
I am city attorney.
We have one now.
Yana, we're waiting on the results of the testing.
Now, why did I have him, Byron, here he comes back, hold on.
Yeah, are you okay if we move the officers to room 1?
Yeah, it's fine with me. Mr. Patel, good morning to you. Mr. Leadbetter, can you unmute yourself, please, Mr. Leadbetter? Press *6, Mr. Leadbetter, to unmute yourself, please. *6 to unmute yourself, Mr. Leadbetter. Put you in 11, Mr. Patel. And I'm gonna put Mr. Leadbetter in 11.
Can you hear me now?
I can hear you. I'm gonna put you in 11. Mr. Patel is gonna come speak with you, all right?
Thank you, sir.
You're welcome. Join the room, please. We're waiting on the officer of Lurst, the probation officer Lurst. For Mr. Byron Garrett, they give me a second to ask who is Joel Galvin Pena here? Is Espino Gomez here? Is Otis Gorman here? Is DeJuan Graham here? Mr. Barry, you ready? All right, anyone ready? All right, what about Gardner?
We can do Michael Gardner, Your Honor. We're ready for a trial date, please.
Let's go back on the record, let's go back on the record. Let's call it City of Detroit versus Michael Gardner, case numbers See the case number. City of Detroit versus Michael Anthony Gardner. Case number is SP 15122-391, SP 1687317. Counts 1 and counts 2. Appearance for the record, please.
Good Friday morning to you, Your Honor. Harry Bachman, on behalf of the defendant, would you, sir, please state your full name for the record?
Michael Anthony Gardner.
We were requesting a trial date continuing a not guilty plea at this point, Your Honor.
All right, for SP 15122-391, I'm going to close that matter out. He paid it.
Okay, thank you.
Chris, come back. Hold on now. Come back July 17th, 2020. Who's that making all the noise? Longmire, you have to mute yourself,
I
please.
apologize about that. I'm trying to mute my camera, but it won't let me.
Now you just mute your device. All right, there we go. Trial date, July 17th, 2025 at 9 a.m. Mr. Gardner, if there's nothing further, I wish you the best of luck. Have a very good rest of your day, all right?
Okay, you do the same, Your Honor. Thank you very much.
Thank you, thank you.
Thank you, Your Honor.
Who do you have next, Mr. Bob? You have Mom.
Ms. Lopez.
We need an interpreter.
All right. So then I also have Miss Grant, Mr. Grant, John Paul Grant. Is he in the meeting, Judge? I can't see.
John Paul Grant. Is John Paul Grant here? I don't believe so.
Let me get him here and ask to stand by for a
Hello?
minute.
Hello, yes, I'm here.
Yeah, John Paul Grant's here. John Paul Grant's here.
So let's go to the breakout room, Mr. Grant.
You can put him in one of the open rooms.
Okay, I'm putting him in 7 with the court's permission, please.
Good morning to you. 7, that's fine. As long as it's not 4 or 1.
All right, we're gonna go to 7. Mr. Grant, go to 7. Judge, I'll be back. Thank you.
Your Honor, this is Attorney Marable. Is the results from Mr. Garrett drug testing back?
No, I haven't. As we call, I'll let you know as soon as we get it.
Okay, thank you.
All right. Is that Officer E. Brown? I don't know how Miss Barrett got him too.
Yes, sir.
That's Officer E. Brown.
That's me, sir. How you doing? How you doing, Judge? Good morning.
I'll put you in a breakout room. Good morning to you. The Spanish interpreter for all right, as soon as this city attorney signs on, we're going to get back pretty good, but give me a few minutes. I'm going to see if I can identify anybody that we can get out of here quick. Horn, they're waiting on you in 4. Good morning to you again.
Okay, got it. I had to click on the live stream. Thank you, Judge, so much. Okay, join room 4.
Right back. Okay.
No.
Stewart?
It's Ariel Stewart. They misspelled my name.
Oh, okay. Ariel, gotcha. All right.
An L instead of an E at the end. I mean, a L instead of an I at the end.
I see. Okay. Ma'am, did the two of you have discussions and were they fruitful?
Yes.
All right. Anything you need to put on record, Ms. Ingen?
Yes, Your Honor, we have a consent judgment, and I can place those terms.
Okay, what are the terms?
So this is, there's rent to retain possession of $330 with court costs of $175 for a total of $505. The redemption date for this judgment is June 30th, 2025. Under further orders, it says that this judgment will be set aside if paid in full on or before June 30th, 2025, because this is the first hearing. We went over again MCR 4.201J, and Ms. Stewart gave me permission to sign her name to this consent judgment.
All right, Ms. Stewart, did you understand all of that?
Yes.
All right, so that's a good resolution. If you pay the $505 by June 30th, they'll set aside the judgment, so it won't affect your rental history. Okay? And did you agree to let Ms. Ingen sign your name on that judgment?
Yes, Your Honor.
Okay. And ma'am, you understand that if you enter into this agreement, you'll be waiving of those landlord-tenant rights that you learned about earlier today. You'll be waiving your rights to a trial. There will be no trial of any kind on this issue.
Yes, Your Honor.
Okay, and you understand under 4201, the court rule, you have 3 days to file a motion to set aside this judgment if you have cause to set it aside. You understand that?
Yes, ma'am.
Okay, and do you have any questions for the court?
No, the 50, well, yes, I paid the 505 through the hub, right?
Just the normal, however you normally would pay it.
Okay.
Yes, ma'am.
Okay.
Okay, so you want me to enter this, Ms. Stewart?
Yes, Your Honor.
All right, we are all set then. I'll sign the judgment upon receipt, and Ms. Stewart, just do what you can to pay that so you can have that judgment set aside, okay?
Yes, ma'am.
All right, have a good day. You're all set.
Thank you.
And we don't have anything again until 2, and it looks like, or I'm sorry, till 10, and it looks like we only have 2 at 10. And then at 10, and then we have one at 10:30. And that's it. So we'll put your defaults on at, I want to give them a little bit more time, okay? I just don't want to put them on and then have to call you. So let's just give them to 10 or 10:15, and then we'll start calling.
Sounds good. I'm happy to do them even at the end all at once if that's easier.
All right. All right, thank you.
Or it makes more sense. So, all right, thank you.
Thanks. All right. Ma'am, can you mute? I have someone in the courtroom. I believe it's Michelle Bolden, but I need you to unmute, ma'am, so I can have your hearing. And I'll ask you to unmute.
Hi.
Hi. Great. Ma'am, is this Michelle Bolden?
Yes.
Okay, great. Ms. Bolden, I have you checked in. Good morning. Can you turn on your camera? I'm going to have you watch a short video. It'll tell you all your rights as a tenant in a landlord-tenant proceeding. And then right after that, we'll start our hearing.
What I gotta.
Do you see, Ms. Bolden, somewhere on your Zoom, you should see what looks like a little video camera. Oh, okay. There you are. We've got you. Okay, good. Ms. Bolden, I'm going to share a video with you. You have to watch the whole video and pay attention. And when you're done, we will discuss your case, okay?
Okay.
All right. Here you go.
The information contained in this video explains your rights as a tenant when your landlord has filed a case to evict you. They may also be asking the court to order you to pay money. You must watch this entire video. The judge will ask if you watched and understood the entire video and if you have questions about it.
Please be advised you have the following rights. You have the right to hire an attorney. If you cannot pay for one, the court must give you information about any legal aid assistance there might be for your area. You have the right to have your case heard in the county or district where the property or any part of it is located. Look at item 3 on the summons, Form DC 104. If the landlord has checked the box stating that the case is not being brought where the premises is located, you can ask the court to transfer the case to the county or district where the property or any part of it is located. You can ask the court to move the case by filing a request motion in writing before the court date listed on the summons, or ask the court in person at the first court hearing. You have the right to demand a jury trial. If you want a jury trial, you must tell the court at your first court appearance or make the demand in writing within 5 days of the court explaining to you your right to a jury trial. You can use Form MC-22, jury demand, and file it with the court. You must pay a $50 fee when you make your demand or within 5 days of the court explaining to you your right to a jury trial. You do not have to pay the jury fee if you have asked the court to waive fees and the court has approved your request under MCR 2.002. If your landlord has asked for you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, MDHHS, a local coordinated entry agency, a housing assessment and resource agency, a federal help for homeless veterans program. You should have received information on local rental and housing assistance with the summons. You do not need a judgment against you to receive help from the aforementioned organizations. A copy of the summons and complaint from your case are enough. You may be able to reach an agreement with the landlord by going through a Michigan or local community dispute resolution program. You can find a program at courts.mi.gov/CDRP. You may be able to reach an agreement with the landlord that will mean the case gets dismissed. The court must provide you with the form for this or tell you where to find it online. This concludes the presentation of your rights. If you are in a breakout room,
Ms. Bolden, did you understand the content of that video?
Yes.
Okay, do you have any questions about your rights as a tenant?
Yes, I did. On the complaint I received, it did not have a,
Ma'am, I'm having a real hard time hearing you.
Can you hear me now?
Yeah, a little better. You're just real muffled. What was that you said?
Okay, the documents I received, some of them did not have a case number on them. I'm not sure that I was properly served. I was understanding that I had 21 days to file a written answer, and I'm not for today because I'm prepared for the 21 days.
Okay, I'm not sure what you mean about the 21 days. I do have notice that you were served in the file through posting, and that they also requested a second mailing, that something was clearly received by you because you're here today. So past that, what is the other issue?
There's no case number on the complaint, and I was wondering, is that filed appropriately? And I thought,
yeah, I have a case number for you. I mean, it's on all of the paperwork I have. So it's 25012414.
Yes, but should it be in the copy that I have?
Okay.
Some of them is not on the complaint, and some of the other documents, don't the case number supposed to be on all of the documents?
I mean, it should be. I see the initial. I don't know if it's because they didn't have the case number yet. Because it wouldn't have been on the documents that you received prior to the filing. But Ms. Bolden, none of those are, necessarily defenses in landlord-tenant actions. So you have two options today. You can ask for a 14-day adjournment that I'll grant so that you can get whatever you need to get together to prepare for your next hearing. Or if you're applying for rental assistance, that will give you time to fill out that application and get all of that paperwork filed. Or you can meet with the attorney from the apartment complex today and see if you can resolve this matter.
I don't have 21 days to file a written answer.
No, ma'am, this is a landlord-tenant proceeding. You can certainly file a written answer if you'd like.
Okay.
But under Michigan court rules relating to landlord-tenant proceedings, I'm limited in the amount of adjournments I can grant. So I can grant a 14-day adjournment so that you can adequately prepare for the next hearing.
I do have a question about my rights.
Okay.
During the whole my tenancy here, I've requested maintenance repairs that have not been done. I have gave uninformed consent on documents by threat. I asked for copies of those records. So I have not gotten any of the copies of the records that I requested. and I was not given a copy.
So are you saying, Ms. Bolden, are you saying, and I'm just asking you this because you're really difficult for me to understand, so I want to make sure I'm following you. Are you saying that you have filed multiple maintenance requests relating to your unit and you requested copies of your maintenance requests?
No, I requested multiple maintenance requests that were not done.
Okay.
And I requested copies of documents that I signed in the scale office giving uninformed. I was told that my subsidy would be affected if I didn't sign it. I was not allowed to read it, and I did not get copies. And I want the copies that I signed that was unlawfully withheld.
Okay, well, I don't know anything about that. Ms. Engen, do you know anything about some documents that she would have signed relating to her subsidy?
Your Honor, I don't. My client might have some more information. I'm wondering if, you know, I know that the summary proceedings are accelerated, but perhaps in the 14-day adjournment period, Ms. Bolden might be able to file a written answer listing out the maintenance issues and the documents that she's asking copies of. And then once we have that list, we can make sure that it gets taken care of.
Okay, so Ms. Bolden, I think that's listen, the house is uninhabitable, or if you have, you know, significant maintenance issues that affect the habitability of the home, that's certainly a defense. Okay, so I agree with Ms. Engen. I'm going to give you some time. We'll adjourn this 14 days to July 3rd at 10:30 a.m. And that'll give you an opportunity, if you want to file something with the court, that's great. I want to put you in a room before you leave with Ms. Engen, not to necessarily discuss a resolution, but just so you can give her an idea of these documents, so that she can speak to the apartment complex and try and get whatever paperwork exists, okay?
Okay.
All right, so we'll put you in and you two have your discussion, and I'll see you back July 3rd at 10:30 a.m. Ms. Bolden, you'll see something asking you to join a breakout room. Just go ahead and enter that breakout room so you can explain to Ms. Engen some of the documents or some of the maintenance issues you've had so that she can discuss it with her client, okay? And get you whatever paperwork you need.
Okay, can I just send it to her? Because I'm not good. I'm not prepared. I have a disability, and it's.
All right, well, Ms. Bolden, if you want to just send it to her, what I want you to do, you have email? Do you have email?
No, I don't have access to that on my own, no.
All right, well, I'm going to put you in a room so you guys can at least exchange contact information, okay? So you know how to get a hold of her to tell her what you are missing when you had a chance to think about it, okay?
Okay.
So you're going into room 4, join that room, and that way you two can have a discussion and exchange contact information.
Thank you.
Yep, thank you. Good morning, Miss Roby. I have you checked in. Your hearing's not until 10:30, but you're checked in on the docket, so you could just mute and keep your camera off or whatever you're comfortable with. And as soon as I get everyone here on your case, we'll call it, okay?
Okay, thank you.
Thank you. Hey, I have a phone in the courtroom. It just says Tori phone. Can you tell me your first and last name?
I'm sorry, Tori and Full of Love.
And Tanisha Full of Love.
All right, I have a D. John Fuller on the docket. Is that? I think at 9:30. Oh, 1 second. Full of Love?
Yes.
Okay, you're late for court.
We couldn't get, I don't know what was wrong with Zoom. I couldn't get on there, so I had to get another phone and download Zoom, and that's how I got on here.
Okay, we did not call the case yet, so you're good. We didn't do a default yet. So this is Tori Ann and Tanisha Full of Love.
Yes.
I like your last name. It's fun.
Thank you.
Yep. All right. I've logged you, checked you in. Give me just a few minutes, okay? I'm gonna play a video for you.
Okay.
I've got a phone in the courtroom. It just says Motorola Moto G Power. Can you tell me your name? I'm asking you to unmute. I want to check you in for your hearing.
Okay, you there?
Hi, yeah, sir, can you tell me your first and last name?
Carrie Lee Johnson.
Sam.
It's the 10:30 transfer case.
10:30. What's the last name, sir?
Johnson. Johnson.
Oh, Carrie Johnson?
Yes, ma'am.
All right, I have you logged in. I'll change your name. Just sit tight. You're a little early, okay? As soon as we get everyone here, we'll get rolling.
I'm sorry about that, ma'am.
I'd rather have you late or early than late. So just sit tight with us and let me get everyone here. Okay.
Okay, I'll sit right here.
Thank you.
You're welcome.
And I've got Mr. Nancy coming in too. Good morning, Mr. Nancy. I have you checked in for court.
Yes, ma'am.
All right, so you could just, no, Mr. Carey, you could just mute. I'm gonna mute you, okay? And as soon as we can, we'll get back with you. I need a very brief recess. The people second hearing. Okay, Miss Roby. We have Miss Roby and Miss Ingen here. And this is our second hearing. This is 25011854, the people versus Alexis Roby. Ms. Roby?
Yes.
Thank you. And Ms. Roby, we have you here too as well. So this is our second hearing on this case.
Yes, they said that I was there the last week, but they said that they rescheduled it. I didn't know. I was on Zoom for like 3 hours.
Oh, okay. Ms. Roby, have you been advised of your rights? Did you watch a video last time you came?
I never was in court. They had.
All right, so it's a first hearing. I've got you. All right, and then I also have Miss and Miss Fullalove, both are here. And neither of them have seen the landlord-tenant video either. So we'll get to the two of you in just a second. I'm gonna play a video for you. And then Miss Nanasi, is this your second time in court?
No,
Or your
ma'am.
First. Okay, perfect. That video's for you as well then.
Thank you.
Mr. Carey, is this your first time in court? You're muted.
There we go. Are you there, Your Honor?
Yeah, is this your first time in court as well?
Yeah, yes, with you, Your Honor.
Okay, did you watch or learn about your rights as a tenant in a landlord-tenant proceeding previously?
Yes, ma'am.
You did.
I know my rights.
Okay, all right, then everyone else, let me see if I've got anyone else we need in the courtroom. Dake.
Okay.
You see a Dake? All right, I'm gonna play a video. It's a landlord-tenant video. The five of you, it'll tell you all of your rights in a landlord-tenant proceeding. So it's important that you pay attention. And then at the end of the video, I'll ask you some questions, okay?
Okay.
Great.
Yeah. The information contained in this video explains your rights as a tenant when your landlord has filed a case to evict you. They may also be asking the court to order you to pay money. You must watch this entire video. The judge will ask if you watched and understood the entire video and if you have questions about it.
Please be advised you have the following rights. You have the right to hire an attorney. If you cannot pay for one, the court must give you information about any legal aid assistance there might be for your area. You have the right to have your case heard in the county or district where the property or any part of it is located. Look at item 3 on the summons, Form DC 104. If the landlord has checked the box stating that the case is not being brought where the premises is located, you can ask the court to transfer the case to the county or district where the property or any part of it is located. You can ask the court to move the case by filing a request motion in writing before the court date listed on the summons, or ask the court in person at the first court hearing. You have the right to demand a jury trial. If you want a jury trial, you must tell the court at your first court appearance or make the demand in writing within 5 days of the court explaining to you your right to a jury trial. You can use Form MC 22, jury demand, and file it with the court. You must pay a $50 fee when you make your demand or within 5 days of the court explaining to you your right to a jury trial. You do not have to pay the jury fee if you have asked the court to waive fees and the court has approved your request under MCR 2.002. If your landlord has asked for you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, MDHHS, a local coordinated entry agency, a housing assessment and resource agency, a federal help for homeless veterans program. You should have received information on local rental and housing assistance with the summons. You do not need a judgment against you to receive help from the aforementioned organizations. A copy of the summons and complaint from your case are enough. You may be able to reach an agreement with the landlord by going through a Michigan or local community dispute resolution program. You can find a program at courts.mi.gov/CDRP. You may be able to reach an agreement with the landlord that will mean the case gets dismissed. The court must provide you with the form for this or tell you where to find it online. This concludes the presentation of your rights. If you are in a breakout room, please return to the main session. Please be patient while you are waiting for your case to be called.
Okay, great. Miss Roby, did you have a chance to listen to that video and watch that video in its entirety?
Yes, ma'am.
And did you understand your rights?
Yes.
Do you have any questions about the content of that video or your rights?
No, ma'am.
All right, Ms. Roby, you have two choices right now this morning. You can ask for a 14-day adjournment, and we would come back on July 3rd and hear the case at that time. Or you can speak directly with the attorney for Taylor Community Development, the courtyards, and see if the two of you can reach some sort of agreement today.
Okay, I would like to talk to the attorney.
Okay, I'll put you in a room and Miss Ingen will be with you in just a few seconds, okay?
Okay, thank you.
All right. All right, I'm putting her in room 1 for you, Miss Ingen.
Thank you.
And then I have Miss Tanisha Fullilove and Torianne Simpson.
Yes.
Did the two of you have a chance to watch and listen to all of that video?
Yes, ma'am.
Okay, is the other one with you? Your camera's not on, so I can't see who's there.
Oh, I'm sorry.
Yes, I'm here.
Here we go. Hi, okay, you're both there?
Yes.
Yes.
Okay, and did you both watch and understand that video?
Yes.
Okay, and did you hear me say to the person in front of you, you can request a 14-day adjournment so that you can get your paperwork together, your finances together, whatever it might be, or you can apply for rental assistance if you qualify, or you can meet directly with Miss Ingen, the attorney for the ponds, and see if some sort of agreement can be reached. What would the two of you
Yes.
like to do?
Yes.
Yes?
Yes, I want to talk to the attorney. Yes.
All right, we'll put you in a room. Miss Ingen's got someone in front of you. So just give her a couple minutes to get in there and just sit tight. She's coming, I promise, okay?
Okay, thank you so much.
All right. And I'll put them in room 2.
Thank you, Your Honor.
Okay, yep. And then Mr. Nassie,
Yes, ma'am.
did you understand that video in its entirety?
Yes, I did.
Do you have any questions about your rights?
No, I do not.
Would you like to meet with an attorney from the apartment complex, or would you like in, wait a second. Aaron Dake is your landlord. Let me bring him in. Mr. Dake, you're with us? Mr. Dake, can you unmute?
Yes, I'm here.
Okay, thank you. So, Ms. Nancy, you can request a 14-day adjournment under the landlord-tenant court rules, or you can speak directly with your landlord today to see if you qualify for, or if the two of you can reach some sort of agreement. What would you like to do today?
If we could have a short discussion, and then see if I can try to get some assistance.
Okay, are you talking about applying for rental assistance?
Yes, I have an application started. I just need some, I just needed some numbers from today to add to my application.
Okay, well, I'll put you in a room with your landlord, but I want you to know, Ms. Nancy, under Michigan court rules, you have to apply like ASAP, because you have 5 days to submit a form. You have a pen?
Yes, I do.
You have to submit form DC 539. That's available on Google. You just type in DC, Michigan DC 539, it'll come right up. Or you can come into the courtroom, and if you come or into the courthouse, and we have those available at the window for you, you can fill it out here. But under the court rules, you have to submit that within 5 days of today. We need to have that paperwork in the file for future adjournments. Understood?
Oh, I was talking about help through Michigan Department of Health and Human Service, MDHSS, MDHHS.
Yeah, I know. Whatever kind of aid you apply for, when I say DC 539, it's got like 2 questions on it. It's a form where you have to submit to the court that says you applied through rental assistance, who you applied through, when you applied, and then you sign it. But we have to have it in the court file under Michigan court rules.
Oh, okay. I apologize. I missed that step.
So you fill out your aid request and you submit your aid request, and then you just send something to the court, and it's this simple form that basically puts us on notice that you've submitted a request for assistance through whatever agency you may apply through. Understood?
Understood. Okay, I'm sorry. I missed that step. Okay.
No, it's okay. It's just, I say this stuff all day long, so.
Understood.
So you wrote down the form you need to send us?
Yes, I did.
DC 539.
I have that information. Yes, ma'am.
I've already spoken with him, Judge, so.
All right. Well,
you want to take him up first when I'm finished? I'll be more than happy to.
all right. We'll
And
try
Judge,
to be brief. Yes, Mr. Dean.
I was just going to say, well, I think we have pretty much everything resolved.
All right.
So he just
Okay.
needs to run over those things.
I think that's the only one in custody, Judge. Do you want to take that up right now first? Is that what you want to do?
We can do that. Why don't we?
Okay, let's do that.
We are on the record in the 13th Judicial District, the District Court of Greenwood County, Kansas. Case number 24 TR79, State of Kansas versus Douglas E. Brogan. Please announce appearances.
State of Kansas, approved by and through Assistant County Attorney Paul Leadbetter.
Richard Paul on behalf of Mr. Brogan, who appears in custody at the Greenwood County Jail.
We are here on a motion to revoke the defendant's probation. Chief Court Service Officer Cheryl Wheeler is here. And it is alleged that the defendant has violated his probation by not paying as directed, still having a balance of $368 out of the $468 ordered over a year ago. He's failed to report on multiple occasions, including December 30th of 24 and January 13th and February 10th of 25. He has violated the law, at least in Woodson County, where he on March 20th of 2025 had count 1, criminal threat, a 9-person felony, and count 2, driving while suspended, a 3rd, dismissed in exchange for plea and conviction, to driving under the influence of alcohol and drugs, a 1st, and transporting an open container. It is also alleged that he has pending in this county aggravated domestic battery from 24 CR 224. So then it is further alleged that he tested positive for alcohol and marijuana on November 18th, 2024, for which he served a 48-hour probation violation sanction. But then on February 10th of 2025, he had a UA in which the urine was not of adequate temperature. resulting in an invalid finding, and he was told to return to participate in another UA by 12 p.m., and he failed to do so. The Woodson County Bond Supervision reportedly told the court service officer that he has admitted to using marijuana and alcohol on 2/12/25, which was the day that the urine was not of adequate temperature, and he did not return for a second test. Miss Wheeler is here as records custodian, apparently, and as supervisor to the probation officer, Jessica Morgan. Do we need to proceed with evidentiary hearing, Mr. Paul?
No, we do not, Your Honor. Mr. Brogan will admit to the violations. He will remain silent on the Greenwood County case because he still has the presumption of innocence on that one. It is true that he did take that plea offer in the Woodson case. He would admit, he basically, except for discussing the Greenwood case, he would admit to 1, 2, 3, and 4 and waive his evidentiary hearing.
Okay. I'm going to check one factor. All right, at this time, Mr. Brogan, your attorney says you wish to admit your violations except the one. Do you understand you do have the right to an evidentiary hearing and to compel the state to present evidence to prove the violations if they are able?
Yes, ma'am.
And you wish to not have that hearing and admit to the violations?
Yes, ma'am.
You understand that admitting to the violations most likely leads to your probation revoked, and then whatever happens, the court must decide the disposition independent of any negotiations?
Yes, ma'am.
All right, and knowing this, have you had any promises or threats made to cause you to waive your right to a hearing or enter these admissions?
No, ma'am.
Very well, I will find that you have freely and knowingly entered your waiver of hearing and your stipulation of violations under the advice and evidence of Mr. Paul. Do you need any more time with Mr. Paul before we proceed?
No, ma'am.
Then I do find that you have violated your probation. I do revoke it. As far as disposition, are there any recommendations? Mr. Dean, on behalf of the state.
This is, my recommendation is I don't believe that the full 12-month sentence is necessarily appropriate for the type of offense that's underlined, but I would just be requesting the court to issue some type of a sanction, that he serve that sanction, that the balance of this case be sent to collections for collection, and probation be terminated unsuccessful, or the case be closed. Excuse me.
Okay, let me see if I understand the history of this. Per sentencing, he served 48 hours in the county jail, and then he served the balance of 90 days on house arrest. Is that right?
As far as I know, Judge, yes.
With electronic monitoring.
A judge, actually need to go back and review that myself.
If you would, please.
I don't. And
yes, ma'am, that was correct.
Well, I want to see verification that he did it.
Yes, 90 days to be served by 48 hours in the Greenwood County Jail starting June 15th, 5 p.m. with the balance on electronic house arrest with windows for work, probation, and medical treatment. Livestock, okay, I remember this specifically. Livestock care is limited to 30 minutes per day.
All right, Ms. Wheeler, are you showing that as well, that he served the initial 90 days and then another 2 days as a sanction?
Yes, Your Honor, I would agree with that.
So he has 92 days in of his 1-year sentence.
When was the 2 days sanction done? I don't recall.
November.
Okay, so that's something imposed by court services.
Court services, yes,
Correct.
that was.
Okay.
All right, Mr. Paul, your recommendations or comments?
Judge, my comments are this. Mr. Brogan's a single parent. He does have a full-time job. He does work in Yates Center. I'm not trying to minimize the activities he did on probation. Judge, I would ask, since he served basically 92 days out of a year, what I would ask this court to do is modify the sentence, give him an additional 30 days as a sanction, and then close the case as outlined by Mr. Dean. Because Mr. Dean wasn't asking for the full year either, Your Honor.
Well, this is the defendant's third driving while suspended. The parties did recommend a 1-year sentence. He was granted probation. He has not complied with that probation in many, many ways. I won't go through them all again because I've already done so. At this time, if a year was appropriate at sentencing, a year is appropriate now more than ever because he's added all of these violations to it. So I am going to order that he continue the balance of his sentence, which looks like it's about 273 days. That's my order.
Judge, did we get a bench warrant? Ms. Wheeler, could you tell us when we served our bench warrant? Since ours is the older case, I think we should probably be granting it credit as well from whenever we got the bench warrant served, Your Honor.
Yes,
And
credit for
as
all
long
time.
as when he was in custody, that is.
It appears that he was arrested in Woodson County on March 13 and bonded out on March 14, according to the return warrant.
But now that would be time for Woodson County. That wouldn't count for us, would it? Or was it our warrant that he?
It was our warrant, but he was just in there a day, and then he bonded, and he's apparently currently being held on other charges. So I guess I'd say he gets 93 days at this point in time.
All right, 93 days it is. All right, we'll be in recess, and Mr. Brogan is remanded to the custody of the Greenwood County Sheriff. Thank you for being here, Ms. Wheeler. Unless you're here on another matter, you're excused.
Your Honor, I trust that you also accept the balance of the case before, to collections.
Balance of money owed to collections, yes, because it'll be a while before he can pay it. All right, we'll give a breakout room to Mr. Paul. Who do you want first?
Let's just go in. Let's go Miss Martin, Marsha Martin.
Martin it is. Miss Missy or Missy, do I have you back now full time?
Yep, I'm here.
Okay, thank you.
Judge, just give me a few minutes and then we'll be ready to rock and roll.
Will do.
You know how I operate.
I do to some extent, to a large extent, I think.
I love the qualifier, Judge.
I've been sent to join the breakout room, but
Yeah,
I just dismissed it.
Okay.
I'll be here in the background, Judge. So whenever
All right,
it's
so will I. Thank you.
be ready.
I got kicked out for some reason. I don't know what happened.
They put Mr. Paul, gave him the option by mistake. For technical
Well,
issues all over the place.
No, I had to reopen them and
Oh,
as I become host and it did something weird.
And it sent it to me, Richard, and I put not now. So, that's what I clicked. So I think that threw you out as well.
I got you. Okay, Judge, I'm ready and I've got kind of, right, first case we'll take up is Mr. Mock. 25.
In 2025 TR 162, State of Kansas versus Adam Mock, Paul E. Dean for the state, Richard Paul for the defendant, who also appears personally. Mr. Paul.
Judge, after speaking with Mr. Dean, Mr. Mock is eligible for diversion. He's going to avail himself to that. Just like a 2-month diversion app hearing date, please.
Well, I won't extend it any more than that. Why do we need so long?
Just to get the paperwork back and forth, Judge. It's usually 2 months. That's what we usually set him at.
I thought over here it was a little quicker than that, but I'll do it. Mr. Dean, you think you need a full 2 months?
I know it seems like there's always some kind of a delay, so I don't have an objection to it. I think it can be done faster than that, but I'm not going to object to the time frame because I would expect it to be fully completed at that point. So.
Well, the problem I have is that so many times they don't get it done the first time and then they want another time. So, Mr. Dean, I'm going to hold you to make sure that doesn't happen, that this is it. 1 8-month continuance for 8 months, 8 week for diversion and no more. So, Missy,
Your Honor, he's already got his evaluation finished, Judge, so this ought to be pretty smooth.
All right, and then we can get him off the docket so I can use that date for someone else.
I understand.
Okay, Missy.
August 15th at 11.
Okay, you must be diverted or be back here August 15th at 11, Mr. Mock.
He understands, Judge.
I will continue your bond with that condition. We'll be in recess on Mock then.
Okay, let's take up Miss Martin.
We'll be on the record in 25 TR 78, State of Kansas versus Marcia Martin, Paul E. Dean for the state, Richard Paul for the defendant, who also appears personally. Mr. Paul?
Judge, same announcement as the last case. She is diversion eligible. She's going to do diversion. I would just ask for the 8/15 date and we'll get everything done, hopefully much sooner than that, and unclog your docket, Judge.
Thank you. Mr. Dean, any objection?
No, Your Honor.
Then, Miss Martin, that will be the order of the court. You must be back here August 15th at 11 if you're not diverted by then, and your bond will continue with that condition. Any question about that, Miss Martin?
No.
Nope. And if she has questions, Judge, I'll be more than happy to answer, as always.
Was that August 8th? I apologize.
15th, August 15th at 11.
August 15th it is, and if there's nothing further, we'll be in recess and Miss Martin is excused.
Thank you. Miss Winger?
We will be on the record in 2025 TR 35, State of Kansas versus Bridget Yinger. Paul E. Dean for the state, Richard Paul for the defendant, who also appears in person. Mr. Paul?
Judge, same announcement, diversion eligible, would like the 8/15 date at 11.
All right, that will be the order of the court. Ms. Yinger is continued at the defendant's request to August 15th at 11 unless she is diverted. And in the meantime, Ms. Yinger, you will be continued on your bond with that added condition.
Okay.
Thank you. If there's nothing further, we'll be in recess, yes?
Yes, we'll take Mr. Williams up next.
All right, Ms. Yinger, you are excused as we are in recess. We are on the record in 2025 TR 70, State of Kansas versus Lewis Williams, Paul E. Dean for the state, Richard Paul for the defendant, Lewis Williams, who also appears personally. Mr. Paul.
Judge, Mr. Williams just had major surgery. He is unable to speak at this moment. I've talked to Mr. Dean about that. We're going to both basically ask a joint continuance for 1 month, Judge. Let Mr. Williams heal up a little bit.
No objection, Mr. Dean?
Yeah, sure. I don't see any way we can proceed with Mr. Williams not being able to audibly answer.
Very well, Missy, your closest date to 1 month?
I have July 18th available.
Let's do
July
that,
18th at
Missy.
10. All right, Mr. Williams, you are continued at your request to July 18th at 10 o'clock. You must be back here at that time, and your bond is continued on the condition that you reappear July 18th at 10. There's nothing further. We'll be in recess on Williams. Mr. Williams is excused at this time.
Let's take up Mr. Eckles next, Your Honor.
We are on the record in 25 TR 80, State of Kansas versus Ecwan Eckles, Paul E. Dean for the state, Richard Paul for the defendant, who also appears in person. Mr. Paul?
Judge, I don't believe Mr. Eckles is present.
Defendant fails to appear. Any reason why he's not here?
I haven't had no contact, Judge. I cannot address that.
Mr. Dean, your response, if any?
The response is I wish he was here and would enter the plea that Richard and I worked out, but since he's not, I'm going to ask for a bench warrant. And
There's a 2,500 surety through AAA.
bench warrant bond forfeiture, and if they could give us a hearing date for a proposed bond forfeiture hearing.
All right, bond forfeiture hearing.
And
What do you need, about 90 days for that?
I think we've been setting them about
60.
3 days. Yeah, 60. Okay.
Yeah, 60. All right, what do you have something missing?
Yeah. Gonna have to go a little bit longer than that just due to days off. How about September 12th at 9?
Perfect.
September 12th, 9 a.m. is the bond forfeiture bench warrant hearing. New bond set at 5,000 cash for surety. If there's nothing further, we're in recess on Eckles.
Judge, we'll take up Mr. Gilbert next.
We're on the record in 2024 TR 198, State of Kansas versus Zachariah Gilbert, Paul E. Dean for the state, Richard Paul for the defendant, who also appears in person. Mr. Paul.
Judge, I have relayed an offer made by the state. Mr. Gilbert is wanting to basically further discuss that with me. I don't think we're going to get it resolved today. I would just ask for a month.
This is a driving while suspended and no insurance. He's been coming in here since May 28th, 2024. He had a bench warrant issued on first appearance. He had Mr. Paul appointed April 8th of 2025, so he hasn't had you very long.
No, and so
well, we need to get this resolved. I don't know what his issue is, and I don't know that it's appropriate to have to know, other than this is your last continuance, Mr. Gilbert. You've postponed this way, way, way too long. So how much time? How about the next available date?
sure.
Let's see.
We have either July 18th or August 1st.
July 18th. I'm more likely not going to be here August 1st. So I'm
Yeah,
trying to keep that date light.
Yeah, Missy, let's not put anything else on August 1st.
Okay.
What time, Missy?
10 o'clock.
10 o'clock. Perfect.
We ought to be back here, Mr. Gilbert. If you fail to appear again, you'll probably have a no bond hold until we get this resolved. Any questions about that, sir? My expectation for you to be here?
No questions.
All right.
Get in touch
Thank
with
you.
me.
Will do.
Done. Judge, let's take up Mr. Richardson.
Hello, Your Honor.
Good morning. We're on the record in 23 TR 831, State of Kansas versus Mason Richardson, Paul E. Dean for the state, Richard Paul for the defendant, who appears.
Turn
Mr.
on your
Richardson?
video, please, Mason.
I'm here.
There he is.
All right, Mr. Paul.
Yes, Your Honor. Pursuant to plea negotiations, Mr. Mason's going to plead no contest to driving while suspended first. The joint recommendation is going to be $100 fine, court costs, booking fee. We'll have to inquire about court-appointed attorney fee. We're asking for, the joint recommendation is going to be for a 90-day underlying sentence and I believe 6 months of non-reporting probation. Mr. Dean is shaking his head. We just, so yes, 6 months of non-reporting probation.
Mr. Dean, that is your recommendation or your agreement?
Yes, Your Honor. This is one of those cases that was originally supposed to be a diversion, but that never got accomplished. So it's a first-time offense. So hence the reason for the recommendation.
Has the insurance already been dismissed for proof?
I believe at this point in time, it's just there's 2 counts, plead to one, dismiss the other. Your
Okay.
Honor. I don't know. It may have been taken care of, but in any event, that's the agreement.
All right. So, Mr. Richardson, how do you plead to driving while suspended?
Guilty, Your Honor.
No contest. Thanks.
I apologize.
All right. So no contest. By pleading no contest, you're not admitting that you drove while suspended in Greenwood County, Kansas on August 5th of 2023, but you don't want to deny it and take it to trial. Is that correct? You don't want to admit it, or do you? All right, we're going to try this again because you cut out.
No contest.
Okay, I understand that.
Yes,
but I
ma'am.
want to make sure you understand no contest. You're not admitting the charge. Is that correct?
Correct.
Yes, ma'am. That's correct.
And you don't want to deny it and take it to trial. Is that correct?
That is correct.
Is
Your Honor.
anyone making you enter this no contest plea by any threats or promises?
No, Your Honor.
All right. For factual basis to this, Mr. Dean, we have a probable cause arrest affidavit, August 8th of 23. Is that your offer for?
Would proffer that as well as the certified driving record showing that he was in fact suspended on that date. And I would expect, as Mr. Paul typically does, he would also stipulate that that would be sufficient for a factual basis.
We do, Your Honor, and I forgot to make that announcement. I usually do. So.
Yes, you do. All right. I accept the defendant's no contest plea to driving while suspended and find the state has offered a factual basis to support it. The defendant is guilty of driving while suspended. No proof of insurance, if not already dismissed, is dismissed on motion of the state. And at this time, I will follow the agreement. Mr. Richardson, can you hear me?
Yes, Your Honor.
You are fined $100. You are assessed $108 court costs. You're assessed $45 booking fee. And where do you work, sir?
I umpire softball.
Is that a full-time job?
No, Your Honor. I work on a pipeline in Alaska part of the year, and then I do this the other part of the year.
I'm going to order that you pay $250 towards your court-appointed attorney fees. Your sentence will be 90 days in the Greenwood County Jail. I will suspend that so long as you successfully complete 6 months of non-reporting probation. You do not have to see a probation officer, but for 6 months you are on probation. I can't see your face, Mr. Richardson. I need to, because I'm having a lag in making sure you understand me. Do you understand that you have a 90-day sentence that is suspended as long as you complete a 6-month non-reporting probation?
Yes, Your Honor.
Do you understand that if you violate that probation, you can't end up serving your time?
Yes, Your Honor.
The first condition of your probation is that you violate no laws of any kind. The second is that you pay all the money owed that Looks like that comes to about $502 approximately. How much time do you need to pay that?
Just a month or two be fine.
I'm ordering
I plan on coming.
You what?
I plan on coming to pay most of it Monday.
All right, I'm going to order that it be paid in full within 60 days. If you don't have it paid, you have to come back to court at the courthouse in person. So Missy, when's his payer appear?
Let's do that August 15th at 11.
August 15th at 11, you must be here in person at the courthouse in Greenwood County if it's not paid in full.
Yes, Your Honor. Now, can I pay it online or I need to come in person and pay it?
You can pay it online. You need to call the clerk and she'll tell you how to do that. Their number is 620-583-8153.
Okay. Thank you, Your Honor.
You're welcome. Anything further, Mr. Paul?
No, Your Honor. Thank you.
Mr. Dean?
No, Your Honor.
And then we'll be in recess and Mr. Richardson is excused. Zach Gilbert was excused, was he not? Do we still need him for any reason?
No, we do not need Zach Gilbert for any reason, Your Honor.
Zach Gilbert, you can hang up or Missy can dismiss you.
We'll take up Miss Robinson next, Your Honor.
We will be on the record in 2025 TR 73, State of Kansas versus Samantha Robinson. Paul E. Dean for the state, Richard Paul for the defendant, who also appears in person. Mr. Paul.
Yes, Your Honor. Speaking with Mr. Dean, we were going to ask for a little longer continuance than usual because Miss Robinson, we both anticipated that she was in the process of getting her license back. I've just found out today that she does have that back, but I don't have a copy to send to the county attorney yet. So, Judge, I would ask for the 7/18 date so I can show proof of insurance to the state, and we would be amending that charge for.
Have you seen this driver's license, Mr. Paul?
I have not, Judge, but I don't. Talking with Mr. Dean and looking at her driving record, it wasn't going to be really a big reach for her to get it back. So, if she's telling me she has it back, I just haven't seen it, Judge. So
she was on diversion, so she must have not had it. It must have just been one administrative action she had to clear up.
Well, let's see. Her charge says driving while suspended second or subsequent.
Yeah, but
that may have been an incorrect statement, then, Your Honor.
Well,
so, Ms. Robinson, are you telling the court that you have a valid driver's license?
I do. So what happened was I had gotten it.
You don't have to go into it. I just want on record that you're telling me you do have it. Okay. Yes. So, Missy, do you have a July 18th date?
Yes.
All right. I'm continuing your case to July 18th at 10 a.m. You must be back here at that time, Ms. Robinson.
Okay.
You do have a bond, and I'm ordering you to reappear on that bond July 18th at 10 a.m. Okay. Otherwise, if there's nothing further, we'll be in recess and Ms. Robinson is excused.
Thank you, Judge.
I apologize, Your Honor. I see the confusion that I've just created. She did have a prior diversion case. They had pulled that for me. I was looking at that file instead of the current pending case.
All right. That does explain the confusion. Okay, Mr. Paul.
Your Honor.
Yes, sir.
Actually, I can tell the court right now it's valid, but Mr. Paul would need to speak with her further. Let's just take care of that plea at the next hearing date. But it's on our report now, Richard. So
okay,
we're ready.
Well.
I don't need to send you a report, anything.
You can send it to me. I always like to get mail from you.
Okay, perfect. Thank you, Paul. Let's take up Mr. Warden next.
We're now on the record in 24 TR 519, State of Kansas versus David Warden. Paulie Dean for the state, Richard Paul for the defendant, who also appears in person. Mr. Dean.
Does appear.
I don't think so, Your Honor. I believe we're at a bench warrant time, and I believe we have a plea agreement worked out on this matter, but he also failed to appear back on June 6th, according to my notes, unless he came in late.
Yeah,
So that is not.
No, there was a continuance granted.
Yeah. You continued me a 2-week continuance to try to get a hold of him. I have not been successful, so I think we just need to warn him at this time, Judge.
Okay, and that's not him at the Greenwood County Courthouse, correct?
Correct.
Well, how many failures has he had?
I just think the one.
Yeah. I think he had been participating up until the last hearing, Judge.
Yeah, he was appeared.
Because they provided some documentation, but it didn't resolve the matter, and then that's.
All right, the court will order a forfeiture of his $1,000 OR bond, bench warrant. Any recommendation for new bond, Mr. Dean?
Your Honor, at this point in time, I think Mr. Warden may need to, this is an older case as well, 24 TR. I think Mr. Warden maybe needs to see the court before the court sets a bond.
No bond hold it is. If there's nothing further, we'll be in recess.
Just for the record, I need to ask for another continuance.
Continuance denied.
Thank you, Your Honor.
For the record, it is noted.
I'm noted on the journal entry.
Thank you very much, Paul. All right, pick up Mr. Squire.
We will now be on the record in 25 TR 81, State of Kansas versus James Squire, Paulie Dean for the state, Richard Paul for the defendant, who also appears in person. Mr. Paul.
Judge, pursuant to plea negotiations, Mr. Squire is going to enter a no contest plea to drive while suspended third. We would rely on the affidavit as the factual basis that was filed by Deputy Blake Fisher on March 4th of 2025. Judge, the joint recommendations of the parties is going to be a 6-month underlying sentence. There is a mandatory 5 days in jail. Mr. Squire has informed me that he believes he's already served 5 days in the Greenwood County Jail, but I would need Mr. Dean to verify that. 12 months.
Doesn't he have to serve more than that on a third?
No, Your Honor, that 90-day, the court's got authority, obviously, as you know, to order whatever sentence is believes appropriate. That 90-day mandatory kicks in when it's related to a prior DUI conviction, and then you have that third or subsequent violation. That's where the 90 days. His history is not associated with DUI, just driving while suspended and failure to appear and insurance. So.
Well, I'm showing a 90-day minimum. That's what I'm thinking of. But he may have to serve that depending on his reason for suspension.
So the minimum sentence would be 90 days. That's not required to be served. But the statute's a little bit bizarre in that it states 5 days for the second. I think one could argue that it doesn't even really require the minimum 5 days for the second the way it's written. But I always believe that it's appropriate to at least do the 5 days, as well as if it had been a DUI or alcohol-related suspension, then the 90 days would be actually a mandatory serve. My interpretation of it. It's the way I've done it.
And your fine recommendation?
On this one, it's $500 for the drive while suspended and $50 for the registration, because he's also pleading to that with the state agreeing to dismiss count 3. I believe that was the no insurance charge.
Correct.
Yes. Count 3.
Yeah, plead to 1 and 2, dismiss 3, Your Honor.
Okay. Anything else, Mr. Paul?
Judge, also Mr. Dean has offered 6 months early termination as long as he's in no more trouble and has all of his fines and fees paid off.
What, Judge? So let's put it this way. So 6 months controlling sentence, 12 months reporting probation. I've advised Mr. Paul that as a incentivizer here, that if Mr. Squire has no further legal issues and takes care of all of his liabilities under this case by the 6-month time point, he may file a motion requesting early termination.
Hi, Mr. Squire, are you working at this time?
At this moment, I am in treatment in Wichita at Options, and I've been in here since 6/11 of 25. It's a 28-day stay.
Okay, so you're about a week into that. No, you're a couple weeks into that. Okay.
You got about 19 days left by my calculations, Your Honor.
Okay, and then
And
you're going to
then-
have okay, so I didn't remember you having is it alcohol or drugs?
It's a drug.
A drug?
Yes, ma'am.
Okay, what's your addiction?
Methamphetamine.
Oh, boy. Well, Mr.
Yeah.
Squire, I'm seeing you too often. Let's just put it that way. And so whatever this treatment tells you to do, you better get with it. Because
ma'am.
I would sure hate to see you spend a long time in jail or prison because you keep getting into trouble. At this time, you will be, well, let me ask you about your charge first. I haven't even done that. How do you plead to the count of driving while suspended, a third conviction?
No contest, Your Honor.
By pleading no contest, you mean you don't want to admit the charge, but you don't want to deny it either?
Yes, Your Honor.
And you don't want to go to trial?
No, Your Honor.
And even though you're not admitting it, do you understand you'll still be found guilty and will not be able to appeal that conviction?
Yes, Your Honor.
Same with registration. How do you plead to count 2?
No contest.
And you don't want to admit that or take it to trial?
Yes, Your Honor.
All right, and let's look at the affidavit, and I've looked at that a little bit already. This was out on Highway 400, clearly inside of the county, Greenwood. You had a small child with you, it looks like.
Yes, Your Honor. And it was on a minimum maintenance road
All
off
right.
of 400.
Okay, well, based on the defendant's plea of no contest, which I find freely and knowingly entered, and the affidavit, I find that the state's proffer through that affidavit supports a no contest plea. The defendant is found guilty of both counts 1 and 2. Count 3 is dismissed on motion of the state for plea agreement. On count 1, the sentence is 6 months in the county jail. The defendant will be given a 12-month reporting probation. So as soon as this hearing is over, you must call the main number for probation. Do you have your pencil ready?
Yes, Your Honor.
Okay, it's 316-322-4153. And that's as soon as you finish this call, you call them. And you're going to have to serve 5 days in jail. And when will he be serving that, Mr. Paul? Have you talked about that?
Judge, we need to run a jail credit because we think he's done his 5 days. We think
All right.
And
Go ahead.
Misty's usually able to get that information for us.
All right. Let's pick a date in case he doesn't have his 5 days. When's his treatment end? 28 days from when?
19 days from now.
Outside.
So you get out the 9th, I think, 9th or 10th of July by my calculations, Judge. But don't hold me to that.
What's the second Friday in July missing?
The 11th.
All right, I'm going to order 7 p.m. July 11. You must check into the jail unless your attorney tells you otherwise.
Okay.
Take your photo ID just for good measure, although I think they'll recognize you.
That was
Okay.
July 11th.
July 11th at 5 o'clock.
unless you've done your 5 days. And then your fine is $500 on count 1, driving while suspended. Fine is $50 on count 2. I will not impose sentence on that one. You will pay court costs and booking fee. I will waive attorney fees since you're in treatment.
Thank you, Your Honor.
And then I'm going to order that you pay 1/12 of the total due each month. First payment will be due July 20th. And then you'll have 1/12 due on the 20th day of each month thereafter until paid in full. If your probation officer, and I'm going to order that you continue the treatment you're in, including any aftercare. All standard conditions will apply. That means no alcohol, no illegal drugs, Mr. Squire.
Yes, ma'am.
James, once you call me Monday, and we should have the jail stuff figured out by then, whether you have to report or not, okay? Can you do that?
Yes, sir. Can I write your number down real quick?
Yes, 316-303-0100. And
okay,
we'll see how much credit you have, and you may not have to serve any time if you've already served it.
Okay, I appreciate that.
Thank
Anything
you.
else we need to take up, counsel?
Oh, Your Honor, thank you.
I'm about to say, Your Honor.
Mr. Pelham.
Mr. Squire, you're excused and we're in recess on your case. We will now be on the record in 23 TR 300024, State of Kansas versus Cedric Pelham, Polly Dean for the state, Richard Paul for the defendant, who also appears in person. I show this is for a diversion revocation, folks.
That is correct, Your Honor.
Yes.
Announcements.
Judge, he hasn't paid. I think the only outstanding issue was payment. He's a college student. He's had a rough time trying to pay it, Judge. He hasn't paid it off. Mr. Dean had offered if he could pay it today, he was going to withdraw that motion, but Mr. Pelham doesn't have the money today. So we're kind of at the mercy of the state and the court at this point, Your Honor.
All right, so the defendant admits the motion, acknowledges that he has not paid as contracted.
That is correct, Your Honor.
And Mr. Pelham, you agree?
Yes, Your Honor.
You understand you could have a hearing and make the state try to prove you haven't paid, but you want to waive that and admit you haven't paid?
Yes, ma'am.
Then I will find the defendant has violated his probation or his diversion. Diversion is revoked. The contract apparently has a provision that we proceed with trial on stipulated facts. And
yes.
Yes, Your Honor. I mean,
okay.
he's already stipulated, Judge, so you can.
I think the court can just find him guilty on counts 1 and 2.
Yes.
I'd be recommending a $300 fine on. Oh, you let me know whenever you want to do that. Sure.
I will find him based on the stipulation of facts in his diversion agreement. I find him guilty of counts 1 and 2. Sentencing, Mr. Dean.
Your Honor, on count 1, I'll ask for a $50 fine. On count 2, I'll ask for the mandatory minimum $300 fine. Court costs of $108. I believe a booking and processing fee. He was imposed. He was booked and processed, so and that would have been part of the diversion as well. So $45 on that. Given his college status, Your Honor, student status, I'd ask the court. I'm not going to oppose court waiving appointed attorney fees on this matter. Ask the court to place him on a 90-day underlying sentence on count 2, suspended for 12 months of probation. No sentence is requested. Underlying sentence is requested on count 1. This will give Mr. Pelham the opportunity to create a payment plan with court services and gets that taken care of, and wants to come back and ask for consideration of an early termination, the state certainly would be opposing that, given his first time offender status.
Mr. Paul, anything further?
No, Judge, I would join in all the recommendations outlined by the state, including the waiver of attorney's fee due to his collegiate status.
What year are you in, Mr. Pelham?
Ma'am, I'm sorry, you cut out.
What year are you in school?
I'm going to be class of 2027.
So what year does that make you?
It's going to make me a junior.
Okay, you're talking about going into the fall as a junior?
Yeah.
Okay. Okay. Are you involved in academics, athletics?
Yes, ma'am. Academics and athletics.
All right.
He's a football player, Judge.
Okay. Very good for apparently Monroe College.
Yeah.
All right. At this time, Mr. Pelham, I did find you guilty based on stipulated facts. So for count one, now I show count one as driving without a license, Mr. Dean.
Yes.
That's correct.
And your recommendation was?
I recommended 50 just because the nature, just because the mandatory minimum is 300 on the no insurance on it.
50, and then as far as jail time, you recommended no jail time on that one?
On that one, and 90 days on count two.
Okay.
Recommended for the 12 months reporting so that he can get into a payment plan and get to
Okay. All right, so I'll follow that recommendation, Mr. Pelham. Did you ever get your driver's license?
No, ma'am. I get to go home. I get to go home in August, and I live in Texas, so then I'll just get it when I get back in Texas.
All right, well, you're gonna have to talk to your probation officer about getting that transferred or how they want you to do that. But at this time, on count one, driving without a license, your fine is $50, no jail time. On count three, the minimum fine required by law is $300. That is ordered. A 90-day sentence is ordered. So if you don't want to serve 90 days in the Greenwood County Jail, make sure you comply with 1 year reporting probation. You have to contact court services as soon as this hearing is over. Their number is 316-322-4153. If you do not call them, that's your first violation of probation, and I'm not going to put up with violations of probation.
Yes, ma'am.
90 days will be your sentence if you violate. So call probation. All standard conditions will apply, and they will go over them with you. You must report as directed. You must get your driver's license as a condition of your probation, or at least make every possible effort to get it. If you physically or mentally cannot get it, then I will consider that. But otherwise, I expect you to have a valid driver's license. And in addition to your fines, you're going to have $108 court costs, $45 booking fee, $60 supervision fee, and then I will waive your attorney fees. But I think you're going to have about $563. And how soon can you pay that?
I would say about maybe
Well, Judge, that's was part of the probation, was to let him go onto a payment plan. So
All right.
All
right, then I'm going to order that you pay at least a 12th each month of the total due. Your first payment will be due July 20th, and then on the 20th day of each month thereafter.
Oh, okay. How much is like a 12th of it?
Oh, 563 by 12, Mr. It's approximately what you said.
A little under.
Okay.
Oh, so make sure you get that paid. How old are you?
I'm 24 years old.
Okay.
Call probation after court, Cedric. They can tell you where to make your payments and everything. Okay.
Okay.
And you be sure and talk to them about how you're going to do your probation. You're out of state right now?
Yes, ma'am.
Yes, he is.
Wonder if we're gonna have to do an interstate compact one way or the other. Where's home? You talked about home. Where is that?
Texas.
And where are you now?
I'm in Washington.
Okay, you're in Washington. Home is in Texas. We may have to do that. That could be a nightmare. Okay, call
Your
them
Honor,
and let them do it.
Judge, I know that they do a lot by Zoom as well, so he might be able to report by Zoom. So
I think that's how they've been handling that, because it's almost impossible to get many states to take on the compact for a misdemeanor.
Yeah.
Well, I just had several conversations with Tony Bauer, Court Service Officer, about when the interstate is mandatory, when it's not. I'll just let them figure it out and we'll go from there.
Sounds good, Judge.
All right, thank you. We'll be in recess. Mr. Pelham is excused.
Your Honor, could we take just a short break before we launch into these last handful of cases we have?
That'd be fine.
that sounds like a great idea, Paul.
Did we take
Right
up
back.
Mr. Mock?
Yes.
Yeah, he was diversion eligible, Judge.
Oh, that's right. They were in the
That was
first.
the first case we took up, and you yelled at me for wanting 2 months.
That's right. Okay. Thank you.
I'll be right back.
Samage, I'll need a quick.
Judge, I think that's the only one that has Mr. Paul, is it? Oh, he's already back.
All right.
Apparently he did away with his client.
We did all of your.
He's at the courthouse, so he couldn't go far. There he is.
What's his name?
Samage Jones, Judge. This is on a motion to revoke non-reporting probation.
We are on the record in 2021 TR 600, State of Kansas versus Samage Jones. Paulie Dean for the state, Richard Paul for the defendant, who also appears in person. As counsel said, this is a show cause hearing on why we should not revoke the defendant's probation. Any announcements?
Yeah, Judge, this is a motion to revoke his non-reporting probation. This is what we're here for. Mr. Jones would admit that he has failed to pay all costs, fines, and fees in this matter. He would forego any kind of evidentiary hearing. Judge, my recommendation to the court, and I'm not sure what Mr. Dean is, but I would ask that the court put him on reporting probation until all of his costs, fines, and fees are paid off. To my knowledge, he has not committed any new offenses, and so it's basically a money thing, Judge. So I would just ask that he be put on reporting probation, but it terminate as soon as all costs, fines, and fees are paid for. And that's all I have.
Well, I have a note that it's already been sent to collections.
Okay, well, if it's already been sent to collections, then Judge, I would ask just that the case be closed.
Mr. Dean, what's your position on it?
Well, he set a cash bond.
And he paid, I think he forfeited that cash bond for payments.
Well, it wasn't marked that way. It was a request for refund of the bond following approval by the judge.
Okay.
But if he just authorizes the release to pay this case, we could be just done with. I mean, it's 2 collections now. If that bond was applied to whatever the collections issue is, I'd be satisfied with them just closing the case.
I think Mr. Jones would agree with that, Your Honor.
All right, we're talking about a $375 bond that he posted May 28th.
There's 5. I don't know what. Oh, it is 370. It looked like 575 down for the initial to have it raised. I'm sure he has some collection costs, but at least that would get that portion of it taken care of.
All right, well, I am going to direct you, Mr. Jones, upstairs to the clerk of the district court and see if you need to sign any authorizations. Upon payment of the money owed, the case is closed. And any motions are withdrawn. Is that right, Mr. Dean?
Yes. He probably should be advised that there's probably, since it's sent to collections, there's
I'll just order that it be
40%
taken.
collection fee added.
I'll just order that it be taken from collections. Will they still?
Oh, yeah, I don't know about that, Judge. But yeah, if the court order it from back, recall from collections.
That's what I'll do. I'll order that it be recalled from collections, that his bond be accepted as payment, and it says conviction. Oh, that says conviction. See when they sent that to collections. Well, it says they sent it to collections May 29th, and that was the day after his cash bond was going to be surrendered. I wonder if he paid. Go to the clerk. I'm going to order that it be taken out of collections. That unless they've already applied the cash bond and he still owes $375, which I don't believe is the case.
I doubt that they've earned a 40% fee for having it for a handful of days, in my opinion.
I would agree with that.
All right. Well, I'm going to close the case either way. So whether it's he still owes or not, and if he owes, it will be in collections. If he doesn't owe.
Thank you.
All right. Anything further? Then you go on up to the clerk's office and see where you stand on that, Mr. Jones.
Okay. Good luck, Samage.
Okay. Now we've taken care of all yours, Mr. Paul.
I believe so, Judge. At the 1:30 PHC docket, our new attorney, Mr. De Hoyos, will probably be appearing on my behalf on all cases.
All right.
So I want to give you a heads up.
Look forward to meeting him. Thank you.
Great. Well, have a good weekend.
You too.
Thank you, Judge.
You're welcome. Let's see. We'll take up North on the record in 2019. TR 870, State of Kansas versus Kevin North. Paulie Dean for the state. The defendant, Kevin North. Is that you, sir? Can you start your audio? Click on that little red microphone looking thing. Should see a little red microphone. If you don't see it, run your finger down the side of your phone or down the bottom. Should see a little red microphone with the line through it, and click on that.
Can you hear me now?
I can, yes.
Okay,
Thank you.
okay. Sorry.
You're Kevin North, correct?
Yes, ma'am.
Okay, I'm showing that April 29th, 2025, you pled guilty to counts 1 and 2. You were fined a total of $150 plus 108 court costs, 45 booking, and you were told to be back today if you didn't have it paid. Have you paid anything, sir?
I have not, ma'am. I called 2 weeks ago I didn't know how this worked. I called 2 weeks ago on a Tuesday because I knew that's when normal court was, and to ask for an extension, and they said that I would have to appear to ask for an extension. if I may, I'd like just 30 more days. I just recently started working at the little cafe here in Burden. So I could have it paid within 30 days. I've been unemployed and they denied me my unemployment. So, because I have some medical issues and anyway, but I haven't had employment for a minute, and I started at the cafe here, and I feel that I could pay the 300 within 30 days easily.
Well, these charges were incurred November 16th of the year 2019.
Yes, ma'am.
And you haven't been able to pay. I don't know where you've been.
Apparently this had been a bench warrant outstanding, because this was one that Miss Gillette took care of. The plea was entered, I guess, on the 29th day of April 2025, which
Yes, sir.
kind of stood out to me because I apparently hadn't had my hands on this file for quite some time. Looks like there was a ticket issued. Maybe the first court hearing after that was when he appeared and pled at the last one.
I could even, ma'am, if I may, I could even pay 100 today after this. And then if I could just have 30 days to pay the other, I believe it's 203. I believe the total was like 303.
You're going to have, I take it you don't have a valid license right now,
That's correct.
because you're going to have a number of suspension charges for not taking care of this. Those suspensions were incurred in 2020, spring of
Yes, ma'am.
2020. Recommendations, counsel.
Your Honor, if he can get it paid within 30 days, I'm not gonna oppose that, but it needs to be paid because as the court noted, this is a 2019 case.
Yes, sir. 6 years old. I'm ready to wrap it up myself. Thank you.
All right, don't be driving until you're valid.
Yes,
Missy,
ma'am.
Can we continue this to July 18?
Yes.
July 18th at 11 o'clock, Mr. North. You said you can pay a part of it today. Did you tell me that?
I can. If I need to, I can pay $100 today.
All right. Well, call the clerk of the district court to see how you can do that. Their number is 620.
Oh, one minute, ma'am.
Always bring a pen and paper to court.
I have it. I just didn't have it in my hand. Okay. 620.
583-8153.
Okay. Thank you, ma'am.
You are welcome. All right, if there's nothing further, Mr. North is excused. We will now be on the record in 2024 TR 714, State of Kansas versus Jose Moroccan Veliz. Paulie Dean for the state. Mr. Moroccan Veliz, are you here?
All appears to be so.
He's not up here, and he still owes 503. So, counsel?
Bench warrant, 503 cash.
That will be the order of the court. Being in recess on Moroccan Veliz, we'll now take up Jessica Epting on the record in 2024 TR 542, State of Kansas versus Jessica Epting. Paul E. Dean for the state. Jessica Epting fails to appear and still owes $403.
This is the lady who was just here on June 6th. We were talking with her. She was having some kind of issue making the payment online. We directed her to the court. She'd also had a jail sanction she was supposed to serve on April 26th at 5 for 48 hours. I'm just wondering if we shouldn't have Missy double check and make sure that payment hasn't been.
Well, the clerk put a note in the file on July 9th that the defendant claimed she could not pay fines online, but the clerk was able to log on to the site, and her fines for Greenwood County pulled up as payable online. According to the clerk, she just didn't scroll down far enough to see the Greenwood County case. So we want Missy to check and see if she has paid.
She's paid $50 today online.
Bench warrant, what's the balance due? We'll make that cash.
Balance is 403 because she paid that $50 today.
All right, 403 cash bond. That was Jessica Epton.
Did she ever serve that 48 hours back on April 26th?
I don't know.
We need to confirm that, but we can deal with that after we finish this stuff. I'll ask my office to confirm.
All right, and then there's a Mr. Broyles. Oh yes, I see his case. I thought we took that up though. No.
No, Your Honor. I think there was another case with a very similar name.
I see.
This was one back on May 20th. You had directed that the case be pulled out of collections because it was one of those that they just shot into collections pretty quickly.
Okay. Well, we'll be on the record then in 2022, TR 539, State of Kansas versus Matthew Broyles. Paulie Dean for the state. The defendant appears in person and pro se. I still show he owes $675 and that it's in collections. But I also show we're here on a show cause why his probation should not be revoked.
That's correct.
All right.
I had the balance as 553, but there may have been something added when it went to collections. At least that's what's on our motion. Perhaps let's calculate that.
And then he failed to appear for a while. His appearance bond filed May 28th, 25, 2,500 professional through Florio. Well, let's look at the motion. Are you representing yourself, Mr. Broyles, on this motion to revoke your probation?
Yes, Your Honor. I wasn't able to get counsel. I've had some trouble with the weather and work.
Your Honor, this is one that appears to be, it's not currently non-reporting. If Mr. Broyles wants to stipulate that he did it, has violated his non-reporting by paying, which I think is pretty clear by the record, and state would proffer that if we need to have a hearing. State would ask that he just be ordered to, placed on reporting probation, make equal monthly payments until the case is paid in full, and have an underlying sentence. Well, he's already got an underlying sentence, but just convert that from non-reporting to reporting.
Mr. Broyles, you've heard what the prosecutor said. Do you want to agree with that or not?
Yes, Your Honor, I do.
All right. Well, you understand that you do have the rights to an attorney.
Yes, I do, Your Honor.
And
I just want to get this paid off.
All right. You wish to waive your right to attorney. Is anyone making you do that?
No, Your Honor.
And I'll have the record in the journal entry and the docket note reflect that you're waiving your right to an attorney. And do you agree that you have violated your probation by failing to pay as ordered?
Yes, Your Honor, I do agree with that.
And do you also join in the recommendation that I revoke your probation and place you on reporting probation?
Yes, Your Honor, I do agree with the recommendations of the court.
All right, I will make that the order of the court that you be transferred to reporting probation. I'm going to start that out at 12 months. You must call probation immediately at 316. Got your pencil and paper?
Yes, Your Honor.
322 41 322 4153. Call them as soon as this hearing is over. I'm going to add a $60 supervision fee to your probation, but I'm also ordering that you pay 1/12 of the total due each month, starting with the month of July. The payments will be due on the 20th day of each month, until paid in full. If you pay it off early, I would certainly consider early termination.
Thank you, Your Honor.
You're welcome. All other conditions previously imposed do apply. So if you get your probation revoked, you can serve your original sentence.
Yes, Your Honor.
All right, anything further from either party?
No, Your Honor.
No, Your Honor.
All right, then we'll be in recess. Mr. Broyles is excused to call his probation officer.
Thank you, Your Honor.
You're welcome. Anything else from Mr. Dean on this docket, or is that everyone?
I believe, Your Honor, that that's all the files I have. So I believe we've gotten through everybody. There's some real interest to catch up, but outside of that, I think we're complete.
All right, Missy, anything from your end?
That's all I have.
All right. Everybody have a great weekend.
You too. Thank you.
Thank you.
We are adjourned.
We brought a number of parties in. Things are bad now. They're about to get worse when we have our 10 o'clock matters, but I brought those folks in. But in the meantime, we're going to discuss Riverside Estates versus Angel Perk and Jeffrey Ellis. They were served by attachment. They're not here.
I'm here.
Yes. And you're Jeff Ware?
Jeffrey Ellis. I'm sorry, Your Honor.
Jeffrey Ellis.
It's my mother's phone I'm using.
All right, so you're Jeffrey Ellis.
Yes, sir.
All right. So you're there at this lot 14?
No, I haven't lived there for quite some time, Your Honor. It's uninhabitable. Has been since December of 2024. And work recommendations were applied several weeks. And
all right, well, just a minute. Is
okay.
Angel Perk still there?
No, he has another apartment. I'm kind of in between homelessness and living with my parents again.
All right. Do you have any objection to them simply taking possession of this trailer back?
I do is for a few reasons. Number one, I still have property there. I was issued a no trespassing order from showing up at a campsite with a bonfire uninvited, and the police came and issued me no trespassing order. So I'm not allowed at 15717 Withers Road, which has my belongings. Well, the only thing I have left is in this shed, and my jacket was on the couch. I thought I had my wallet in it, and my wallet ended up found by the Sturgis Police Department by the library. So I don't know what the hell's going on. The night the escort from the police came, I asked Jason to lock the place up, and he didn't even shut the door, lock it, or nothing. So who knows what went on there? And Jason Feck.
When was this bonfire?
It was a few weeks back. I don't know, a month maybe or so. I woke up on the couch. I was feeling fine. I was, coherent. I had been drinking. I bought 2 40-ounce beers, and I drank maybe one and a half by midnight that night. But for some reason, I woke up and I saw the bonfire down at Bob's place, and Bob's wife, who I'd never met before, told me I wasn't Bob's friend. And
all right. I guess you're telling me more than I need to know. It sounds like this place is uninhabitable anyway, and nobody's in there.
Yeah,
you have my permission to return to the property and receive retrieve any of your property.
Thank you, sir. I have I have the heating element that would go to the water heater that went out in December. That was the first work order that should have been taken care of. I purchased it
All right,
myself.
well, let's see if we can accomplish this. You go get all your stuff out of there and we'll address this further next Friday.
It's just a box of brand new tennis shoes and some odd and end tools and some wood. You know, nothing serious.
6/27/25 at 10:45.
But
Go get your stuff out of there, and then next week we can discuss just releasing the property.
Okay, well, there is I have an issue with the billing of I'm still getting billed for rent, and there is no running water. There's no electricity.
We're just gonna get you to relinquish the property, and then we'll fight about money damages later. But yeah, this is uninhabitable.
Yeah, there's 3 different kinds of molds growing: white, green, and black. All over. I mean, seriously, all over.
All right, go get your stuff. We'll discuss it next Friday morning at 10:45, and then we'll just give them possession of the premises. And if they're going to fight about back rent, we can do that later.
Okay, thank you, sir.
All right, I'll see you next Friday at 10:45.
All right, you have a nice weekend. Thank you.
All right, thank you.
And I believe that's all for me, Your Honor. So I appreciate the court's time today. Have a good weekend.
We got a couple wrinkles there. That one, it sounds like they've totally vacated and she's going to be subject to default. So we'll just ask for immediate possession next week.
Sounds good, Your Honor. Thank you.
All right, thank you. All right, Miss Malone and Mr. Bradshaw are here. What did I do with that file? This, unfortunately, Mick Bauer is in the breakout room right now. And for our 10 o'clock general civils, we hope to be done here in just a moment. Let me bring everybody in and address those 4 matters. This is file number 25934LT. It's entitled Three Rivers Limited Property Partnership versus Evelyn Malone. Good morning, Miss Malone.
Hello.
We were here last week, June 13th, with Casey Strong. Meg Bauer was here. You indicated you were looking for a place to move to, and apparently they've worked out an agreement in this matter. Mr. Bradshaw, what's the status here?
So, Your Honor, first of all, I reviewed our file and all the notes from Ms. Strong regarding legal aid's involvement in this case. I do not see an appearance. So yesterday afternoon, I did reach out to Ms. Malone and offer her the conditional dismissal, which I believe you have in front of you, which allows this case to be dismissed and stay dismissed as long as Ms. Malone vacates the premises by July 31st, 2025. If she does that, there will not be a judgment. I told her that that was the best we could do, and that was our offer. She indicated to me on the phone anyway that she was in favor of that. The only alternative, I assume, would be to move forward on and request a judgment in 10 days. I don't believe there's any issue because I believe at the last hearing, Ms. Malone stated that she was in fact smoking in the unit. And I think if testimony were provided today by Ms. Tyler, that would also indicate that there was smoking in the unit. She had personal knowledge and personal information to that effect. So long story short, sorry, conditional dismissal is what we're presenting. And it's my understanding Ms. Malone agrees to that, vacate by the end. We did not ask for a money judgment.
All right, Ms. Malone, did you agree that you would vacate by the end of July?
Yes, sir. I did on the phone. I didn't get a chance to talk to my legal aid, a lawyer. I was trying to see if I could do that today, but if not, I guess I just have to.
Well, I'm gonna make her available. I'm gonna have you wait, and Mr. Bradshaw will have him wait a second also. So stick with me.
Yep.
Ms. Tyler, same for you. All right, now, every Friday and Monday, when we have landlord-tenant cases, right in the middle of them, we have several general civil motions. So I have to change my way of thinking. So let's see who all we've got here. Mr. Conley, good morning to you, sir.
Good morning, Your Honor.
I've got a couple people that are here barely. All right, I've got Motorola G. Who am I speaking with? Your microphone is on mute.
Angel
what's your name?
Perk.
Oh,
Angel Perk.
Angel, you're late for your hearing.
I was sitting in the waiting room. I do apologize. I
Well,
did drive
let
over
me
to
tell you-
Jeffrey's.
Yeah, Jeffrey was here. He says he's vacated, you vacated. The place is not habitable. I gave him permission to go get anything you wish to get out of there. And I continued the matter until next Friday at 10:45.
Okay, I appreciate that,
If
sir.
you got anything you wish to get out of there, go get it out of there, and we will address this next Friday at 10:45, okay?
Okay, thank you. Thank you
All right,
so
I'll see
much.
you.
All right, bye-bye.
All right. Remember,
How do I exit?
Just, we call it the.
all right, Miss
little
Perk, I'll
diamond.
you, there, she's gone. All right, now I've got somebody who's a telephone number. Who's here just by telephone?
Your Honor, that would be me, Cheryl Miller.
All right. You were there before and then you disappeared.
Yeah.
All right, Mr. Dylan Ringel, you are there, but I can't hear you or see you.
Yeah, I'm here. I just unmuted. I have the video showing, but for some reason it's not showing me.
All right, just stay where you are for a moment.
Okay.
Mr. Bears, you're here on two cases. Which two are you on?
Here on Ringel and also here on Omni versus Brian Walters.
All right. We're gonna do, and Mr. Polaris, you're here on Bank of America.
That's correct. Cheryl Miller, the defendant.
All right. We will first deal with Mr. Conley's case. Meg, we're gonna take a default here, and then we're gonna need your help with Evelyn Malone, and then we'll free John up. All right, this matter is file 25354 GC. It's entitled Three Rivers Health versus Susan Beers. Mr. Robert Conley is here for Three Rivers Health. He's represented them for a long time. The defendant is not here.
I'm right here.
Oh, she is here. Susan Beers, have a seat over here if you would. I'm sorry, I was looking for you on the screen and you were live in person.
Yeah, I was out there waiting for the Zoom and she told me just to come inside, so.
Yes, it's how we used to do court. All right, this is a motion by the defendant to set aside a default. It isn't really, but that's what I interpreted it as. This is a claim for $3,999.40 plus cost for a total of $4,235.80. Mr. Conley is representing Three Rivers Hospital in that regard. The defendant was personally served with that lawsuit on March 13th of 2025. She did not answer or file any response to the lawsuit, so a default judgment entered on April 17th, signed by Judge Pattison while I was sitting on Siesta Key Beach. He rarely signs any of my civil orders, but I'm gone for a week. Sometimes he will sign some defaults. So he signed the default order on April 17th. The defendant filed a letter dated April 28th. So it's within 21 days of the entry of the order. It isn't certainly in the format of a motion to set aside a default, but I'll read it. My name is Susan Beers, and I'm writing to you because this hospital bill has already been paid a few years ago when I worked at Decorators in White Pigeon. They are still taking my taxes for it. I've even been over to Three Rivers Hospital and talked to the billing manager, and she said this should have never happened because I'm on Medicaid. I've not been to the hospital since they sued me March 14th of 2025. So I set it for a hearing I mean, it would have been a lot easier if she showed up when she was supposed to, but she didn't. So she didn't file an answer, default entered, and then she wrote that letter. So I set it for hearing. In order to set aside a default, you have to show two things. You have to show a legitimate reason for not appearing for the hearing and a meritorious defense. I'm not sure why you didn't answer the pleadings. And your contention is that the bill has already been paid?
Yes. I've even been to Decorators to try to get a paper showing that it was paid, but they told me that they only keep records of it for a few years. So I called their main office and they told me the same thing. They don't keep copies of it for so long. And it's only been like 3.5 years, maybe 4. It was before my father passed.
Decorators was your employer who carried your insurance?
Yes.
Do you know who your insurance was through?
I had insurance through them, and I also had my Medicaid. And like I said, I had been to Three Rivers Hospital and just discussed all of this with the billing manager, and she looked up everything, and she said that I had Medicaid at the time, that this should have never, ever happened. She said she don't know why it did.
All right. Mr. Conley, we deal with these from time to time. First of all, what's your reason for not filing an answer to the lawsuit?
Well, I was in the process of dealing with my mom's passing and cleaning out her house. And in the time I had just got done moving to the address that I was served at. And then shortly after that, I was in a car accident in Sturgis, and it totaled my car, so I didn't have transportation to get anywhere.
All right, Mr. Conley, she has some unsupported allegation that the bill was already paid, and then some unnamed person at the hospital told her it never should have been filed in the first place, when the hospital is the ones that ask you to file it. It's hard to even get a handle on something like this. What's your response?
Well, Your Honor, with all due respect, Ms. Beers is wrong. This has not been paid. I have an open judgment against her in your court. case number 22-791 GC with a $5,447 balance, deciding a consent judgment for $100 a month. That's what I'm getting tax karma on. She made 2 payments and stopped. She claimed the same thing on this case, and I had a file on her before that. So this is now the 3rd file. They billed her insurance, which was Aetna at the time that she provided the hospital on these 2 accounts, and they didn't pay anything. So she needs to get a hold of her. She's claiming Medicaid. She needs to call her Medicaid rep, which is so far old now that I don't think they'll even touch it. But she has never done anything to get a hold of her Medicaid rep, to discuss Medicaid with the hospital, provide the hospital with the Medicaid information. So we just keep going round robin. And I think she has so many accounts for all these years that it happens quite a bit where people get confused, don't understand all these accounts. But yeah, this is wide open and has been billed.
No, when I made that agreement for $100 a week, they had garnished my wages and it was all paid for when I worked at Decorators. Because she said when the bill was paid, they would instantly stop the payments on it. And she told me it was
Well, who
completely
is
paid
she?
off.
You're just somebody, some nameless person somewhere. Who told you this?
It was in the office for the bill, when that did the paychecks and stuff at Decorators.
Oh, Decorators. Do you have
Yeah.
anything in writing from anybody?
No, I don't. That's why I said, that's why I've been trying to get, I was trying to get a copy of it.
Your Honor, she
because-
might be right because this is my 3rd case against her. The first case was from 2017, and that thing has been closed for a while now. It's purged now, but I might have hit her with a wage garnishment on those accounts. Then I got another file, which is open, case number 22-791 for 7 more accounts. And now I got this account for 2 more accounts. She didn't answer. She's bringing up the same defense, and she never does anything to take care of it. And here we sit. I don't even know if she's collectible, to be honest, because right now I don't even think she's working. So
Probably not. As a practical matter, it's going to be difficult like this. I don't
I haven't had
find.
a chance to talk to her about it. I've been calling her and she doesn't answer or return my call, so I'm not sure what to do. But I already filed a wage garn on this one at Universal Forest Products, and then I got this motion to set aside.
All right, I don't find legitimate reason for not answering once you get, and I don't find a meritorious defense. A bunch of hearsay, somebody told me something that somebody told me something. There are other cases there. The motion is denied. What I would suggest you do is call Mr. Conley and try to discuss all of these open cases. There was a repayment agreement that failed, so now they're garnishing your wages and nobody likes that. But I don't find that there's a just cause to set this default judgment aside. And we're all stuck with it.
Well, I don't understand it because I have not been to the hospital until the 14th of March when I had to go in and have an upper GI.
Well, again, that's all in the lawsuit. But what I would suggest that you do is contact Mr. Conley and discuss this. If you go out to the counter, I'll give you a copy of this order, but I've denied your letter request to set aside the default. Even though I'm supposed to construe per pleadings broadly.
I've even got a paper at the house showing that they've been taking my taxes for all this since the first time.
Yes.
Even though it's all been paid.
Well, I don't believe it has been paid.
It was paid. I had the papers and then I moved.
All right. Well, you don't have anything to establish that. So they contend it's owed.
These are different accounts, Your Honor. I think she's just.
Yes, I understand.
Okay.
All right, you go out to the counter and get a copy of the order. I would suggest that you contact Mr. Conley and discuss it further, but I have not granted your order. All right, you're free to go. Thank you.
Thank you, Judge.
All right, we're in kind of the same circumstance. Let me take care of this hanging landlord-tenant case. We had to wait for our legal aid attorney to come back, and then we'll return to our other matters. Ms. Bauer, Ms. Malone is here. They have given her until July 31st to vacate. They indicated Casey Strong and Mr. Bradshaw that they had attempted to contact you on this case, but there was never an appearance from legal aid, and it wasn't clear whether you were involved in the case or not. So Ms. Malone had agreed to vacate by July 31st. They won't pursue any money damages. That gives her actually an additional 40 days to vacate, but she wanted to talk to you further before she completed that. So are you agreeable if I put her in a breakout room with you? And
absolutely, Judge. I did have communication with attorneys Strong and Bradshaw about this case on behalf of Ms. Malone, but we obviously had not filed an appearance.
all right, well, Ms. Malone, click the button that says join the breakout room. Can you see that? You see the mouse there?
No, I don't know how to work this. I have to have it.
Could you help her, please?
I don't want to break nothing. For you.
My staff is very helpful. All right, Elaine, Meg will be here working on other matters. Okay. Some of these are easier than others. Omni Credit Union versus Brian Walters. Eduardo Pilares is here on behalf of the plaintiff. This is plaintiff's motion for summary disposition.
Good morning, Your Honor. Jeffrey Beers, P 41693.
Mr. Beers, you're on that one. I had it backwards.
That's okay. P 41693 on behalf of plaintiff Omni Community Credit Union.
This is a substantial amount for district court standards. $17,045.23 plus costs. Defendant filed a generic answer using the state court form. That gets you past the default, but it does not get you past a motion for summary disposition. In addition, the defendant isn't here. Is anyone here on behalf of Brian Walters? The motion is appropriate on its merits. So I'm not going to show as a default. I'm going to show grant of summary disposition. In the amount of $17,369.33, which includes the damages, attorney fees of $75, and court costs of $249.10. I'm going to sign that order. All right, show it as summary disposition in that amount. All right, Mr. Bear, as long as we got you on the hot seat, let's take up your other matter.
Thank you, Your Honor. On Omni Credit Union, I just want to let the court know that we did prepare a consent judgment on that. We emailed it to the defendant's debt settlement company on June 12th, and they never signed it or sent it back. And we did call several times and could not get through, and they just hung up on us after 4 times. So we're proceeding with our motion for summary this morning, and we stand by it, and thank you for entering the order.
Thank you. All right. All right, let's take your other matter. Dylan Ringel.
Yes, sir.
All right. This is Capital One versus Dylan Ringel. This, and I apologize to everybody, this was the day the courthouse was closed because the power went out. And we're all standing here looking at each other with no electricity. It was set for May 16th and it had to be bumped to today. So people they couldn't figure out what was going on. There was a storm the night before and the power went out. So Jeffrey Beers is here on behalf of Capital One. So this is an objection to garnishment. This judgment entered in the amount of $10,000, $669 plus costs. And the defendant filed an objection to garnishment. And frankly, Mr. Ringel, I don't understand it. You filed the objection to garnishment on the state form in the proper manner and paid the fee, but I'm not sure what your objection is.
Yeah, so I actually did a debt resolution program. And when I signed up for that, the representative at the company had said that they were going to communicate with the debtor or the creditor, sorry, because I had 3 loans, this one being the largest one, that I wanted to have all into one payment. So basically I started paying towards the debt resolution program to lower the payment because I had a job change, which lowered my income. But they never communicated with Capital One. So then I got a notice of wage garnishment. So since then I've canceled that. So, I mean, I'm fine with just paying them at this point.
All right, so what you'd like to do is, rather than have a garnishment, enter in some sort of repayment agreement?
Yeah, I mean, that ideally, that's what I would like to do, yes.
Mr. Barris, what's your take on this?
Your Honor, a motion for installment payments is not before the court today. I'm scrolling through the notes to see if we've had any communication with Beyond Finance. Only a call from Mr. Ringel on April 24th saying that he canceled Beyond Finance. So we would need some more, we need some financial information from him before we could agree to a monthly payment given the high balance.
All right, here's what I recommend, Mr. Ringel. I'm going to deny your motion to set aside the default. You did it on the state form, which I appreciate. The objections are invalid and they shall release the garnishment funds to the plaintiff. What I would suggest you do is today or Monday, come in and file what's called a request for installment payments.
Oh, okay.
And that would set aside the garnishment and set up a payment plan, but they're unwilling to do it at this point because they need more information.
Okay.
It's called a request for installment payments.
Okay. Will do.
All right, the sooner the better for you. In the meantime, the garnishment stays in place.
Okay. Thank you.
All right, you have any questions?
Nope.
All right, you're good to go.
Thank you.
Do you need me to submit an order, Your Honor?
No, you guys did, or my clerk prepared one, so I've got one in here. I find the objections are invalid. The garnishee shall release funds to the plaintiff attorney.
Thank you.
All right. All right, sorry for the disjointed nature of the proceedings this morning, but we're doing the best we can. Thanks.
Thank you. Have a good weekend.
Yeah, I'm working on it. If I get through all this, I probably might. All right, Mr. Polaris, let's take up your matter. Cheryl Miller, can you hear me? Cheryl Miller, can you hear me?
Yes, Your Honor, I'm here. No.
Ms. Miller, we're in
Your Honor,
court.
can you hear me?
Yes.
Okay. Thank you.
I didn't really want to do this by telephone only, but we had to just do the best we could.
Right.
This is entitled Bank of America versus Cheryl A. Miller. This is an old case. Bank of America has been attempting to collect on this debt for 24 years. File number 112086. Defendant was subject to garnishment. There was a garnishee disclosure, and defendant again just filed a state form objection to garnishment, said the funds are exempt without saying anything more. So your claim is that whatever was garnished was exempt. They filed a brief in response to that. And
I'm sorry, Your Honor. Who filed a brief about that?
they
I
did.
haven't received anything. I guess is what I'm trying to say. I haven't received anything.
Let me look. Maybe I got my facts straight. Yeah, dated April 24th, 2025. Plaintiff's response to defendant's objection to bank garnishment. Filed April 24th of 2025. Sent to the River Road address. Anyway, you then submitted some more information. Further complicate things. You don't even live in St. Joe County. This address is in Cass County, and it never should have even been here in the first place, but we're here now. Some white pigeon addresses are in Cass County. Yes?
Can I get the key to unlock the doors?
Yes.
It's ever so slightly locked.
Well, why did you break it?
That's the question. Also, I was told he wants to add something to his order for his next case.
All right, very good. Okay, so we had a long hearing on May 12th. Mr. Polaris was here. We started to make a record. We were going through it, and then you showed up late, and I continued the order until today. There was a question whether the funds were commingled or not. So you submitted some other stuff, which we received. The date stamp on that is May 1st. So, Mr. Polaris, what's your take on this now? This screen seems to be frozen. Mr. Polaris, what's your take on this?
For the record, Eduardo Polaris, P63559 on behalf of plaintiff. Your Honor, this, as you pointed out, this ended with the defendant admitting that she had transferred the alleged Social Security funds to a different account. The issue was whether or not those funds had lost their protected exempt status once she started moving them around between accounts. Defendant was to present additional documentation to be able to show that we could trace those funds back. I understand the court received something. We did not. The defendant did not serve us with whatever she sent to the court. So I'm at a bit of a disadvantage here because I have no idea what evidence is being presented. Obviously, the law is pretty clear on this. If the funds have been commingled, there is no way to separate Social Security from non-Social Security funds. Exempt status is lost. If it's just transferred to another account, the automatic exemption is lost. However, it's up to defendant to prove that those funds come from Social Security only. I don't know if the information for the court shows that because I don't have it.
Oh, wonderful. We probably should have forwarded to you ourselves. Exhibit 1, healthcare questionnaire, healthcare determination notice, 5th, 3rd. All right. Well, I wish I'd have left this case in Cass County back in 2011 because that's where the defendant lives. And then she wrote a letter. I'm not clear as to whether plaintiff owns or has been assigned the rights to present this claim against me. I'm a resident of Cass County and resolve at South River Road, White Pigeon. I have not resided or owned property in St. Joseph County for at least 40 years. And I believe that Cass County is the proper venue for this complaint, which is probably correct, except that was correct in 2011. It's a little late to change venue now. The documents that you sent, Miss Miller.
Yes, sir.
I'm not sure that, what do you claim that they do?
Well, actually, Honor, I have a 5 to 10 minute presentation which covers exhibits, testimony, and to present legal arguments for the record. If I may do that.
I'm not gonna let you do that by telephone. You didn't want to come in here. You didn't want to come in with video, and you've got a presentation that you wish to make by telephone.
Yes, sir.
And you're claiming you never got their pleadings, response to your objection.
No, sir. I do not believe I did. I did send the exhibits to the attorney. I'm sorry, I did send those.
All right. So what you filed on May 1st, you sent to the law firm?
Yes, sir.
Judge, I'm in our paperless system right now. We show nothing received on this, so I'm not sure what happened.
Yes, I did send exhibits and the memorandum of law, I believe I have in front of me.
Certainly, we would like an opportunity to respond. However, a third hearing on this seems a little wasteful at this point.
I agree, but she claims she hasn't seen your pleadings and you haven't seen her pleadings. So I'm going to reset this for a 1 hour hearing live. I'm not gonna let you do this by telephone or without having more information. You filed these pleadings, which frankly, I don't understand them, but you were prepared to make a presentation. But Mr. Polaris hasn't had a chance to review them. When you send them to, you're supposed to send a proof of service indicating that they've been sent, but I will send your pleadings to plaintiff.
Okay. Thank you.
And I will send plaintiff's pleadings to you.
Thank you.
I'll reset this for 1 hour hearing live, date to be determined. I'm sorry, Mr. Polaris.
We won't be able to appear via Zoom, Your Honor?
I have to be in for a penny, in for a pound, so I can't make her appear. Ms. Miller, can you appear by Zoom?
I have tried before. That's why I was late the last time, and I tried. Short answer, it doesn't.
Plaintiff may appear by Zoom. They've been trying to collect on this debt for 24 years, $2,000.96. And you've been ducking the collection for a long time. And they finally got a garnishment that stuck. And your claim is somehow that it's exempt, but I can't quite figure out your pleadings. You claim you didn't get the stuff they sent to you. You claim you sent stuff to them that they didn't get. I don't know whether I believe either of those or not, but we're going to make sure everybody's got everything. I don't have a date right now, and I will set a date, and we'll give everybody notice. All right, so we'll address this further at another time. Mr. Polaris, you will be able to appear by Zoom.
Thank you, Your Honor. We'll see you at that time. I'll await the notice to appear.
All right. All right, so we got sideways and behind on some of our other cases, but let's see if we can resolve Evelyn Malone. Then we'll do the Chevernoy case, and we'll be ready for our damage hearing.
Excuse me,
Ms. Malone, would you have a seat right over here?
Can you grab that order from me? I'm going to make one more notation.
Yes.
Your Honor?
Yes.
Excuse me, this is Cheryl Miller.
Yes.
Are we done with?
Yeah, we're done. I'll let you go.
And we'll.
Thank you.
Well, I didn't like to leave that case unresolved, but it's messy, it's old, and I just kicked the can down the road. We're returning to the matter of Three Rivers LP versus Evelyn Malone. The file number is 25934LT. Evelyn Malone is here in the courtroom. John Bradshaw is here, and Megan Bauer is connected by Zoom from Kalamazoo. We had discussed a conditional order of dismissal where the defendant would agree to vacate by July 31st. She wanted to discuss that with Ms. Bauer, and so we made that opportunity available. Mr. Bradshaw, what's the status now?
So the status, Your Honor, is essentially the same as far as the date. I'm going to present a conditional dismissal. It's Form 508 that states that the defendant shall vacate the unit on or before 7/31/2025. There's no money due. Under further conditions paragraph, I put defendant shall vacate the unit and turn in keys by 7/31/2025, period. Plaintiff agrees to only give a neutral reference to potential landlords. So I've added that part. Box 4B is check stating that if Ms. Malone doesn't vacate by the 31st the next day, I put potentially asked for a judgment and an order of eviction, which is what we're trying to avoid. I've signed it. Do you want me to present it to her to sign?
Yes, please.
Sign it on the second page. Yeah.
Ms. Bauer, have you discussed those terms with the defendant?
I have, Your Honor.
And she's agreeable to that?
I think that she is making a smart decision. And she is agreeable, yeah.
All right. Ms. Malone, do you agree you're gonna move by the end of July?
Yes, sir.
Now, you just entered into a consent judgment here in the courtroom. And when we do that, the judgment cannot be entered or enforced until 3 regular court business days have elapsed.
And just to be clear, it's a conditional dismissal, same effect.
But it's conditional dismissal, but I'm gonna give her the consent anyway,
So
so.
I'll make sure that I pay my rent and utility for the month of July, so I
All
don't
right.
get behind on anything.
And Judge, I did indicate to Attorney Bradshaw, he could put my information in the caption. I don't know if he got the message.
I didn't do that. I wasn't sure. I don't have it. And so.
Yeah,
I'll
it's
just put Nick Bauer.
Okay,
also.
there you go.
Okay. She's
Hey, what's your P number?
84816.
All right, Miss Malone. You've got the rest of June and the rest of July to vacate. And that's better. If they got what they asked for, you would have had 10 days from today to move, and as it is now, you get 40. Hopefully you can find another place to go to, and they'll give you a neutral reference. And they're not ordering any money judgment today. I appreciate the fact you're gonna pay July's rent. That will be helpful. What I want you to do now is go out to the counter and they'll give you a copy of this order. Do you have any questions?
No,
All right, you're free to go.
thank you.
Thank you, Your Honor.
Thank
Thanks,
you.
Mike.
Thank you, John.
All right, we have one more tenant matter. It was set for 10:30. We're about 15 minutes behind, but that is entitled Lamp and Key. Oops, wait a minute.
Oh.
I gave you a lamp and key.
Oh.
Properties versus Trevor Chevernoy. Diana Lamont, the property manager, is here, and Howard Bush, counsel for Lamp and Key, is present. The file number, if I didn't say it, is 24864LT. Mr. Chevernoy is not present. We were here last time on June 13th, indicated the defendant got VA assistance. They were trying to find other housing for him. Mr. Bush, what's the status here today?
I do not believe that he has paid anything further. I would ask my client to confirm that.
That is correct, Your Honor.
All right, well, he was served by attachment, so we weren't able to do the default last week, but we can do it now.
And we have heard nothing further from him.
All right, I think we determined that rent was $800 plus 25 late. Is that what we decided, and $260 in costs?
That sounds correct. There's $55.40 on service fees, the 75, and then the filing fee. So that sounds correct.
What did
I didn't
write
add them up.
130 plus 55.40 plus 75 is 260.40 plus 825 is 1,085.40. Miss Lamont, is he still there?
He is, Your Honor.
Do you think that he intends to pay or move?
I believe he wants to move.
All right. Well, he has until June 30th to appeal, and he has until June 30th to pay it. No money judgment is entered at this time, and a default has entered. Partial payment will not prevent the writ of eviction. Is Stoney somebody working with him on this?
Stoney and I have been in contact on this client, yes.
All right. All right, $1,085.40 due by the 30th of June. Are you subject to being evicted? All right. That finishes our herky-jerky morning. We do have a damage hearing set for 11 minutes from now. We're going to take an adjournment. Thank you. I've signed your order. You guys are good to go.
Thank you.
Okay.
Judge, I'm gonna log out and log back in and then log back out again, if that's okay with you. Just to
Yeah.
fix my phone number. I messed it up last time and I didn't notice it was wrong again. So if I just correct it, it should be, I don't think it should affect anything on your end.
All right, very good.
Okay. Thank you, Judge. I appreciate your help this morning, or your staff's help, and I hope you have a good weekend.
Okay. All right, we'll stop.
I need to get more sun. I'm just looking at the reflection off the top of my head.
Just keep your hat on.
Yeah, if I was a little tanner, it wouldn't flash like that when I turn it and the
Well,
light hits
let
it.
me call this case. This is file number 25435LT. It's entitled Vicky DeMeyer and Chuck Rentals versus Britney Holtz. We had a possession judgment, I think back in March. And this is the time and date for a hearing on the damage aspect of this case. Attorney Andrew Rognes is here on behalf of the plaintiff, and Vicky DeMeyer is present. Britney Holtz is not present. We just called the hall and the bailiff checked to see if she was here, and she is not. Mr. Rognes just gave me an updated list. Ms. DeMeyer, would you state your name, please?
Vicky DeMeyer.
You swear or affirm any testimony you're about to give in this hearing for damages will be true to the best of your knowledge and belief?
Yes, Your Honor.
Your Honor, offer of proof or just cut right to the chase?
Just cut right to it, I guess.
Okay. Hey, Vicky, on the third page of the new breakdown, does it show the damages to the property totaling $1,362.85?
Yes.
Does it also show unpaid rent and late charges until the premises was relet in the amount of $2,145?
Yes.
And does it also indicate the court costs of $90, process server fee, $92.70? Because this is set for a trial, the attorney fee of $150, the certificate of mailing, which I missed, $424.
Yes.
And all that totals up $3,844.79.
Yes.
Did Ms. Holtz have a security deposit of $1,110?
Yes.
After you deducted that, does that leave a net of $2,734.79 for the judgment in this case? I have nothing further on.
All right. Rent is $2,145. Damages as detailed in the accounting are $1,362.85. If we add those up, that adds up to $3,884.79. I don't think we did exactly the same. You got the 2,145 plus 1,362.85.
And then she's got the court costs.
Yeah, I'm gonna put those in a separate line.
Oh, okay, okay. Well, geez, now I gotta do the math.
2,145 plus 1,362.85 is $3,507.85. So we'll deduct the security deposit from that. 1,110 minus 1,110 equals damages in the amount of $2,397.85.
Yep, same number.
All right, 2,379.85. By default. And then we add in the court cost of $336.94. We get your number of $2,734.79. Judgment will be final. We have 21 days to appeal. All right, I appreciate the concise accounting for the rent and the damages, which are not gouged, or the damages seem to be appropriate. And the defendant isn't here to argue about it.
You want me to take the jacket to the
I
clerk?
will. Let me give you this.
Okay.
2,724.79 C order. All right, I didn't know. I expected to have a contested hearing in this matter. We did not.
Well, that's why we made certain that we had all the exhibits out front just to make it go quicker, and maybe she just saw the stuff and
So
said,
I accepted it.
yeah.
All right. Plaintiff. It's defendant. By default. All right, thank you, Mr. Rognus. Mr. Meyer, as your lawyer knows, getting the judgment is the easy part. Getting the money is the hard part, but you do have a judgment in this matter.
Thank you.
Thank you.
Enjoy the weekend.
All right, I hope to. Okay, I think that finishes our herky-jerky morning. I'm going to see what else I've got awaiting me. Try to get out of here for this afternoon.
I'll get you a copy here.
All right.